Can y'all hear me?
Yes, sir. Good morning.
Morning.
Good morning, Miss Roustay.
Hey, good morning, Law Dog.
How are you?
I'm all right. Good morning, Tom.
Good morning. How y'all
You
doing?
doing all right?
I'm doing just fine. We're getting a bunch of rain down here in Wimberley, and all of it's running off, which is typical of the hill country.
Well, you got a pretty place to watch some rain.
Yes, we do. Fortunate.
Jason, I can't remember which college did you attend?
I'll give you a couple of guesses, and the first one doesn't count. I actually my new office here, the previous occupant had the TCU Horned Frog in the background there, and so when I checked out the new office, I knew it was meant to be.
This doesn't create any internal personality conflict at all.
Oh, it does. It does occasionally, but not during football season.
My guess is you treat yourself as a Baylor and TCU fan more civilly than either Baylor or TCU fans.
True.
One another.
True. I'm all for Baylor as long as TCU is not playing head to head against them. So,
Gotcha.
yes, sir.
Okay, it looks like I have all my judges here, I think. All right, Tom, where do you practice?
Actually, my office is in Houston.
Right.
I remember about, oh gosh, 17 years ago now. And so I commute once a week to my office there, and then commute back. My daughter and son-in-law live in Houston, so I take a room with them, and makes it good because I get to see them, you know.
Good. That's good. And what firm are you with?
It's called Fulkerson and Lotz. Wes Lotz is an '03 Baylor grad and law school grad, and he and I have been partners since 2010.
Oh, wow.
So it's been a good deal. He's actually would be judging, except for the fact that he's in trial starting today. So
Oh, good. Oh. Jason, what about you?
I'm in Fort Worth, Stevens Law, do all serious personal injury, wrongful death.
Good. Jen, what about you?
Well, this last year, right before COVID, I retired. I was lucky enough to do some work with Wes and Tom, and I've done work with everybody, but the firm was Higgins Montgomery Roustay, and we had a great time, worked with them about 20 years. And then my kids were in high school, and I realized I didn't want to retire to an empty house. I wanted to retire when it was full of kids and full of crazy. So I retired to my own personal carnival type atmosphere. I've been having a ball doing it, and there was a plan bigger than mine because COVID ended up being a gift. I retired to see my kids, and then I saw them 100% of the time. So it was, God knows a lot more about our lives, I guess, than we do. So it was a good deal all the way around. And they still like me after all that time together. So it's pretty good
Of
stuff.
course.
As does my husband. It's always surprising to me, at least. But anyway, good stuff. But I'm thrilled that Baylor would still want me around, even with skills about a year old and rusty.
Good. Sarah, how about you?
I'm with the U.S. Attorney's Office in San Antonio. It's the Western District of Texas.
Good.
And I'm the chief of major crimes in San Antonio, which handles smuggling, trafficking, anything with a kid, anything with a computer, anything with a gun, violent crime, postal crimes, things like that. And I'm also the chief of the Alpine office, Alpine Pecos Division. And they do a little bit of everything with a large emphasis on immigration because it is a border office. And so I get out to the desert west every once in a while, but live in San Antonio.
Okay. Well, I retired after practicing law, I guess trying lawsuits all across the United States for 36 years from what was then Heartline Dacus Barger Dryer. Now it's Heartline Barger. And I am now at Baylor. I retired in part to help lead the Baylor LLM in litigation management. I'm the program coordinator for it now, which is becoming it is a great degree program, and we're really proud of it here at Baylor and enjoying it very much. And then I also help with practice court and other things while I'm down here at the law school. I don't live in Waco. I get to live back in Dallas, but I'm enjoying the time in retirement after killing myself for too many years. All right, I'm gonna let these other people in so that we can get started. It'll take me just a second to get everybody in, and then we will proceed as quickly as we possibly can. Here we go. I'm gonna admit them all. Let's see. Okay, they'll all be joining here in a second. All good. I'm good, yeah. Okay. I think so. Okay. Do I have the plaintiff on the line, Mr. White? Josh, you need to turn on your microphone and your video. All right, how about the defense? Miss Holden, you on?
Joy Holden here. I'm still in the waiting room for my video, I believe, but my audio is here. I wonder if the host could let me in from the waiting room.
Yeah, I can see you and I can hear you, but I just let you in again. How's that?
Thank you, Your Honor.
Yeah, I have you on here twice for some reason. I'm not exactly sure why that's happening, but Mr. White, are you on?
We spoke with him for meet and confer, Your Honor, so he probably is having some technical difficulties.
I'm not worried about it. There he is.
Yep.
Nope, he appeared and then disappeared.
Apologies. I'm having audio issues. Are you able to hear me?
Can hear you just fine, yes.
I can't hear anyone.
You can't hear us? Obviously.
All right, let's try that. I'm so sorry. Are you all able to hear me?
We
Yes.
can hear you. Can you hear us?
Yes, I can. I can hear you.
Wonderful. All right. And this morning they handed me, I think 15 sheets of paper. And I have yet to figure out how best to organize them so that I don't look like I'm looking down at all times during these proceedings. But I will hopefully work through it as the day progresses. All right. Plaintiffs, are you ready to proceed?
Yes, Your Honor. I'm
Defendant?
hearing some feedback, unfortunately. Okay, I'm not anymore. Yes, Your Honor.
All right. Defense, are you ready to proceed?
Yes, Your Honor.
All right. Are there any pretrial matters? First from the plaintiff.
Your Honor, the plaintiff in this case, my name is Joshua White. I represent the plaintiff in this case, Ms. Gilmore. We have accused the defense in this case, Chimes Department Store, of negligence. But we do have a couple of motions in limine that we'd like to bring to your Honor's attention. And we also have some housekeeping matters that we would like to address as well.
Okay, why don't you address the housekeeping matters first?
Yes, Your Honor. Opposing counsel and myself have stipulated to pre-admitting a few exhibits, particularly exhibits 2 and 6, which I do intend to use during opening statements. I know that we've also stipulated to exhibit 3, and there were a couple of others that we stipulated to as well, if opposing counsel wants to chime in.
Your Honor, the exhibits we stipulated to were 2, 3, 5, 6, 11, and 17.
Is that true?
Yes, Your Honor.
All right. Then I'll go ahead and admit those at this time, and you're free to use them during your opening remarks. All right, what's next?
Your Honor, this is the next housekeeping matter that I'd like to bring to your attention is the plaintiff in this case does intend to call an unavailable witness pursuant to Federal Rule of Evidence 804A. We're wondering if it's Your Honor's preference that we read these statements or call these statements onto the record during motions in limine or at the end of our case in chief.
I would prefer you do it during your case.
Great. Your Honor, that concludes all of our housekeeping matters.
Okay, what else?
You'd like our motions in limine?
Yes, do you have something else?
Yes, Your Honor. So I'd like to start with Exhibit 14. Your Honor, we do intend to admit Exhibit 14 during our, at some point during this trial. By way of background, Exhibit 14 is an exhibit that details a prior incident of an injury that occurred on the defense's property. So we've alleged today that it's because of the defense's negligence that our client, Jordan Gilmore, slipped and fell at the back of their building. During that slip and fall, there were a lot of outlying or underlying conditions that were under the control of the defendant. And it's our belief and also the theory of our case that they were on notice that these conditions had previously been existent for several years. And so we do intend to offer Exhibit 14, which simply gives context to the fact that the defendant was placed on notice that these issues, these safety concerns were existent, and they didn't actually do anything about it.
Response, Your
Are you
Honor?
trying to, let me make sure I understand something. You're not trying to exclude some piece of evidence that they want to put in. You're trying to, it seems to me, are you trying to respond to an anticipated motion in limine?
Yes, Your Honor. We had the opportunity to discuss this exhibit during a pretrial conferral. And because we anticipate that there will be a lengthy objectionary discourse, we thought it might be more efficient to bring it up in motions in limine.
Okay, so this is really not your motion in limine. It's in response to a motion in limine I've not yet heard from the defense. Is that correct?
Yes, Your Honor, unless opposing counsel prefers to address this during trial.
All right, let me make sure that, do you have any other motions?
Yes, Your Honor. Our final motion would be to, as we mentioned, we do have an unavailable witness in this case. It's our expert, Kelly Danes, and we do intend to read on to the record constructively several lines of her prior testimony. This testimony is an exception to hearsay under Federal Rule of Evidence 804A, and we feel it would be more efficient to the court if we just submitted the deposition of Ms. Kelly Danes in its entirety, subject to any objections from opposing counsel. We've also discussed this with opposing counsel during our meet and confer pre-trial, and know that this is also going to be something that potentially involves a bit of litigatory discourse. And so we thought it would be more helpful to bring this up in motions in limine as well.
All right, so once again, this is not a motion in limine to exclude some piece of evidence that the defense wants to offer. It's trying to elicit agreement about submitting the entirety of a deposition as opposed to just what the jury hears. Am I understanding?
Yes, Your Honor.
All right. Okay, in light of those two things, Ms. Holden, what does the defense say? And quite frankly, I also want to know, do you have any motions in limine that you want to address?
No, Your Honor. We'll just respond to the plaintiff's motion. But first, permission to introduce myself to Your Honor.
That's fine.
Good morning, Your Honor. My name is Joy Holden, and I'm joined along with my second chair, Nick Beachy. Today, we represent the defendant in today's action, Chimes Department Store. Now, going to counsel's first motion in limine with regards to Exhibit 14. Permission to screen share Exhibit 14 for Your Honor so you can actually see the document?
That's fine.
So this is that document.
Can I ask you a question? Are you trying to exclude this document?
Yes, Your Honor, we are on two bases.
All right, so this is your motion in limine. You don't want this document admitted. If I
Yes, Your
understand,
Honor.
right? All right.
Yes, Your Honor. Now, first, this document is hearsay within hearsay under Rule 805. There are two layers of hearsay. First, the person who is talking to the interviewer, telling her story, saying that she was hurt outside of Chimes Department Store. A second is the person who interviewed her, who took down those statements and recorded those statements in this document. That's hearsay within hearsay under Rule 805. Additionally, Your Honor, this violates the rule against improper propensity evidence. Now, Mr. White said that he would be using this document to show action and conformity therewith. This document is a prior instance of conduct, that someone was hurt outside of Chimes Department Store in the past. He's using that to show that it would be more likely that the plaintiff in this case was hurt on January 23rd, 2019. So we would ask that it be excluded both on hearsay within hearsay grounds under Rule 805 and under Rule 404 as improper propensity evidence.
What do you say about his notice argument?
Your Honor, it doesn't go to notice because this document was made more than 10 years ago. There's no one here to authenticate the document, no one on the witness list for either the plaintiff or the defendant to actually show that this does go to notice. What this clearly does go to is conformity evidence. The jury is going to take this prior instance of conduct, that someone was hurt in the past, and they're going to see that it made it more likely that Ms. Gilmore was hurt on July 31st.
Mr. White?
Yes, Your Honor. So in response to the plaintiff's concerns about propensity evidence, we're willing to offer a limiting instruction that at no point will we ever offer that this shows propensity. In response to opposing counsel's concern about hearsay, again, we're willing to offer a limiting instruction that we won't be arguing anything on this document as being true. The only reason or the only manner in which we intend to use this document is to show that there was notice. Now, opposing counsel says that there wasn't notice because this happened nearly 10 years ago. Well, the fact that this has been an issue for 10 years is ample notice, and it is highly probative to whether or not the defense in this case met their standard of ordinary care. And so, again, we will offer limiting instructions, and we'll only offer this to show that Chimes was on notice. And in response to opposing counsel's argument that there is no one that can verify or authenticate that this is true, well, that's just not true. We have a good faith belief that they'll be calling a witness who can speak directly to this. And for some reason they're not able to, then we would be happy not to bring this in, but we have a good faith belief that it will come in, and we're more than happy to stipulate to limiting instructions that can kind of satiate opposing counsel's concerns.
All right, one short answer to this question. Does your allegation involve loose concrete?
Your Honor, no, we won't be making any arguments around loose concrete, just that the general area that Chimes was on notice, that this general area had some safety concerns that they were on notice were of concern.
All right, I don't need to hear anything further. Here's what I'm going to rule at this point in time, and that is I'm going to grant the motion in limine, but understand in granting the motion in limine, I am specifically not excluding the evidence at this time, okay? By granting the motion in limine, obviously you know well that means I don't want it mentioned during the opening statement. I want the proper foundation to be laid, and we will address it as it potentially arises during trial. Anything else from the defense?
Your Honor, I just wanted to respond to counsel's second.
I don't need a response. Okay.
Of course, Your Honor.
I thought you were talking about need to respond to the, all right, go ahead. You can respond to the second argument he made on what I think is your motion in limine. Go ahead.
Yes, Your Honor. Now, counsel is certainly free to read portions of the expert deposition, as the expert is unavailable under Rule 804, and the deposition is a prior deposition under oath. It meets all of those 804 requirements. But what Mr. White and I discussed in Meet and Confer was that he wanted to constructively read that information onto the record, meaning I think that he just wanted to enter the document in its entirety. As Your Honor knows, there are time limits for a trial like this, and so a counsel is going to have to read that onto the record and use his time, not just enter the document, just as we are unable to do that.
I agree with you, and you will read what you want to read from that as opposed to submitting the entirety of it. To that extent, that's a motion in limine. it's granted. Do you understand that instruction? You will read only what you intend to use and what you want this jury to hear. Do you understand that, Mr. White?
Yes, Your Honor.
All right. Anything else?
Finally, Your Honor, we would just ask to be able to turn our video off while the other party is giving a statement, an opening statement or a closing argument, such that the jury can focus on the one party.
In that regard, and given that this is a Zoom trial, I would say no. I want everybody that's involved in the trial to be visible. I mean, obviously, witnesses. Part of a trial by Zoom or anything is looking at you. Okay, and I want to have, and I think the jurors would say they want to have their eyes on you, whether you're speaking or not. So that request is denied, and I expect you all to be visible at all times. Witnesses, if you're not testifying, you do not need to be visible. And jurors, if you don't want to be visible, you don't have to, other judges, but if you want to be visible, you're certainly welcome to do so. Everybody clear on those instructions? Okay.
Yes, Your Honor.
Anything else?
And no, Your Honor. With that, we're ready to proceed with opening statements.
All right, let me say this. I let you go a little longer than I should have with respect to these motions, in part because of the way that I think they were addressed. That said, you got 55 minutes per side, and I'm going to be doing the very best I can to keep track of time. Are we ready to proceed? Plaintiff?
Yes, Your Honor.
Vince?
Yes, Your Honor.
All right, plaintiff, you're welcome to make an opening statement.
Convenience first, safety second, responsibility last. The defendant, Chimes Department Store, had a railing removed from around the concrete platform and stairway behind their store. This made for easier access to unload merchandise. Convenience first. Then they ordered their employees to take their smoke breaks behind the store in the dark on the concrete platform using the stairway with missing railings. Safety second. On January 23rd, 2019, my client, Jordan Gilmore, fell off these stairs while taking a smoke break, lost her balance, and landed on her backside. Instead of having her back, the defendant is the reason she landed on it. Because in their eyes, in their pocketbook, responsibility comes last. My name is Joshua White, and along with my co-counsel, Jackson Haddon, we represent the plaintiff, Jordan Gilmore. Now, I don't have anything unusual to say about Miss Gilmore. Before January 23rd, 2019, she would very ordinarily get up, go to work, and do her job. She isn't someone who people complain about. She never expected to find herself sitting here asking her old boss to take responsibility for a fall she experienced at work. But today, that's exactly what she's doing. She's alleged that it's because of negligence on the part of Chimes that she fell in the first place. Now, negligence is a legal argument, and I'll explain that more thoroughly at the end of trial. But for now, I just want you to keep in mind that this case is about ordinary care, the kind of behavior you should be able to expect from anyone. Now, today, the evidence will show that Miss Gilmore just does what she's asked. Nothing more, nothing less. She's going to take the stand today and talk a little bit about her routine. She's going to talk to you about a loading area. Now, this loading area is located directly behind Chimes' building, the building that she works in. A lot happens in this area. Right to the left of that dumpster, there used to be a guardrail, and that guardrail extended down the steps. It provided support and stability for people walking in that area. The evidence will show that Chimes asked to have that railing removed to make it more convenient for their delivery trucks to unload. Now, as I mentioned, this loading area was used for multiple reasons. Take another look at that dumpster. It belonged to Chimes, and their employees were expected to use this loading area to throw out trash. Believe it or not, this wasn't the only use for this area. Today, when you hear from Ms. Gilmore, she's going to tell you that this loading area was designated as the only place employees were allowed to take smoke breaks. So employees like herself often found themselves in this area at least 20 times a week. Now, I mentioned the lack of a guardrail, but you might still be wondering why I'm focusing so much on this loading area. Today, evidence will show that employees would often use this loading area at night. You'll hear that the conditions around this loading area described as pitch black. You'll learn that on January 23rd, 2019, there weren't any lamps outside lighting the area. Ms. Gilmore is going to tell you that the door right there would swing open, especially in windy conditions. Sometimes she'd have to walk around it because it would take up walking space, making her path in and out of Chimes limited and narrow. In addition to Ms. Gilmore, you're also going to have an opportunity to hear from our expert witness, Kelly Dane. She's a professional engineer with a background in investigating cases just like the one you're about to hear. She's going to help you understand that ordinary care I was talking about a little bit earlier. She's going to tell you about some standards that we get from the Occupational Safety and Health Administration. You may have heard them referred to as OSHA. The evidence will show that what these standards require and what Chimes provided aren't one and the same. I want to prepare you for what you can expect to happen during the course of this trial. I'm going to spend a lot of time talking to you about who was in control of the loading area and who was responsible for what happened there. Because answering these questions will be important at the end of trial when you're asked to determine who is liable for Ms. Gilmore's fault. Today, the plaintiff is going to provide you with evidence that shows that the only person who has exercised or exhibited any display of control over this loading area is the defendant. If you can remember that last picture I showed you, I want you to visualize that giant dumpster you saw. That dumpster was in the loading area. That dumpster belonged to Chimes. The evidence will show they ordered it. It'll also show that they never asked anyone, including their landlord, for permission to put it there. They never even notified him that it was there after the fact. When this trial concludes, the facts you're allowed to consider will show that Chimes didn't just have knowledge that their employees, including Ms. Gilmore, regularly use the loading area. They required them to. Today, Ms. Gilmore is going to tell you firsthand that on January 23rd, 2019, she lost her balance. She lost her job, and she lost her dignity. Today's trial is an opportunity to determine who's responsible. At the end of this trial, myself, along with my co-counsel, Jackson Haddon, will ask you to return the only verdict supported by the facts, the only verdict justified by the evidence. We'll ask you to find the defendant Chimes liable for negligence. We'll ask you to tell them that you can't put convenience first, safety second, and responsibility last.
Opening statement for the defense, Your Honor. May I proceed? This is a case about choices. Choices that the store couldn't change. Mr. White just told you that his client got hurt falling off of a loading dock. And members of the jury, that's true. He told you that whoever was in charge of that loading dock might be responsible. That's true too. But then he tried to tell you who that was, claimed that the loading dock was the responsibility of Chime's department store. It told you that it was the store's fault. And members of the jury, that's just not true. You see, Chime's department store is not the only store in their shopping center. They don't own the building, they rent it. You'll learn that the actual owner, the landlord, is a corporation called Kermit Realty. They chose to build the loading dock where Ms. Gilmore fell. They chose to take responsibility for maintaining it, and when something happens because of their choices, they're the ones who are accountable. Members of the jury, that matters because that landlord, not the store, is the one with the legal duty to repair that dock. That landlord, and not the store, makes choices about when to fix those stairs, and that landlord, not the store, will let those lights go out and let those stairs crumble. So today, the plaintiff is asking you to hold Chime's department store liable for someone else's choices. Choices they just couldn't change. Those choices, they matter, ladies and gentlemen, because today the plaintiff has the burden of proof. They have to convince you of four things, more likely than not. First, that they owed Miss Gilmore a duty. Second, that they breached that duty. Third, that Miss Gilmore suffered injuries. And finally, that the breach of that duty was the direct and proximate cause of those injuries. And today, the plaintiff won't even be able to meet the first element of their burden, duty, because it was Kermit Realty, and not the store, that had control over that loading dock. And to see just exactly why the plaintiff will fail to meet that burden, you'll hear from the store owner of Chime's department store. In fact, Ms. Geller, could you turn on your camera for a moment so that the members of the jury can see you? Ladies and gentlemen, Ms. Geller is the owner of the Chime's department store. It's a family business. It was passed down from her grandfather 3 generations to her. And for the past decade, Ms. Geller has been responsible for running that small business in our community. Thank you, Ms. Geller. She'll walk you through that lease, the lease that she had with Kermit Realty Group, and explain exactly what choices her store can and can't make. Well, you're going to see the parking lot in the front, that they're responsible for that. The building, that they're responsible for that, but the alley out back, the loading dock where Miss Gilmore got hurt, you're going to hear that they were not responsible for maintaining that area. You'll hear that Kermit Realty is the only one in charge of making sure those conditions are safe for everyone. But members of the jury, you'll see that the landlord's choices aren't the only ones that Chimes couldn't change, because the plaintiff made her own choices that day. We expect that the plaintiff will testify that she's walked up and down those stairs hundreds of times before. In fact, Mr. White told you exactly that in his opening statement. She's walked at rain, at night, in all sorts of conditions without any problems. We expect that she'll admit that on January 23rd, 2019, that night was different. And that on that day, she chose to walk on the very edge of the stairs, these stairs. The evidence will show that she didn't have to make that choice. On that day, she lost her balance. On that day, another employee reached out her hand to try to help, but instead of taking that employee's hand, the plaintiff chose to jump off the stairs. You'll learn that night the plaintiff made choice after choice that Chime's department store just couldn't change. That's why we've raised an affirmative defense of contributory negligence. That means that if we can show that it's more likely than not that Ms. Gilmore acted unreasonably that evening, that she didn't exercise ordinary care, you can hold her personally accountable. So as you listen to the evidence today, I want you to think about what Chimes did and didn't have the power to do. Did they have the power to change property that they didn't own? Did they have the power to change the plaintiff's choices? We expect you'll find the answer to both of those questions is no. Chime's department store didn't have a choice. But you will. That's why at the end of today's trial, I'll come before you again, and I'll ask you to find the defendant not liable. Thank you.
I got to unmute myself. Sorry. You can call your first witness. Final.
Your Honor, the plaintiff calls Jordan Gilmore to the stand. Good afternoon, Ms. Gilmore. Please introduce yourself to the jury.
My name is Jordan Gilmore.
Where are you from?
I'm from right here in Waco, Texas.
I'd like to start by helping the jury get to know you a little bit better. Ms. Gilmore, what do you do for a living?
Well, right now I'm currently unemployed.
And have you always been unemployed?
No, I used to work at Chimes department store.
What is Chimes exactly?
It's a department store that resembles sort of like a Macy's, but it's not as high end. It sells more cheaper items than like a Macy's would, but we have a little bit of everything.
What was your position at Chimes?
I was a cashier.
Now, you mentioned that you previously worked there. Why aren't you there now?
I had a fall and I was unable to work after that.
Now, I want to talk about that fall in a moment, but first, did anyone at Chimes reach out and try to help you get back to work?
No.
So what happened to your position?
Well, and I was better after the fall. They had already replaced me, so I couldn't return.
How long have you been working at Chimes at this point?
I had worked there for about 10 years.
Ms. Gilmore, I want to turn your attention now to January 23rd of 2019. Can you tell me what happened that day?
Yes, I was working at Chimes that day, and that's the day that I had my fall.
And around what time was that?
It was about 7 o'clock that night.
Was the sun still out?
No, it was pitch black outside at that time.
Were there any street lamps to help you see?
No.
How was the weather?
It was very cold and very windy. Just a typical like January weather at night in here in Waco.
Now, you mentioned that there weren't any street lamps that were giving you light. Were there any lamps out there at all?
There is a light on the side of the building, but it wasn't on.
Were you able to turn it on?
No, we didn't have access to a switch or anything that would let us turn it on.
Now, can you give us a little bit of information about what you were doing before your fall?
Yes, I was taking a smoke break.
Ms. Gilmore, I have to ask, is that allowed?
Yes, and we're actually instructed to take our smoke breaks in that area.
Referring court and counsel to what's already been pre-admitted as exhibits 2 and 3, I'll let the record reflect the opposing counsel has copies of these exhibits. Your Honor, permission to publish to this witness to lay some foundation and then to the jury?
Well, it's already up, and I believe these are already admitted, so you can proceed.
Ms. Gilmore, do you recognize these?
Yes,
What are these pictures of?
this is the loading area where we take our smoke breaks.
Now, is there any other reason why you had to be in this area?
Yes, this, as you can see in the picture, this is where our garbage bin is. So we take the trash out here as well.
On average, how many times a week would you say that you're in this area?
I would say probably 20 times a week.
Now I'd like to discuss the actual details of the fall that you mentioned. Was anyone with you?
There was a coworker out there, Riley.
Where were you when you were, where were you specifically located, when you were outside?
I was down the stairs while I was taking my smoke break.
And after you made it down the stairs, what happened?
That's where I stood to smoke because I didn't want the smoke going back inside the building. So I went down the stairs and stayed down there while I was smoking.
Was there a railing attached to the wall you might have been able to grab onto for support?
No.
Is there any way that you were able to try to get support?
Well, as I would go up and down the stairs, I would just put my hand on the wall for support as I was going down, just because there wasn't anything else to hold on to.
Ms. Gilmore, as you climbed up the stairs, what happened?
When I was coming back up the stairs, Riley was holding onto the door. And so as she was holding it this way, I had to step around it to try and get back on the landing area.
And what happened as you were making your way up?
Since I was blocked from the actual area, I was stepping around it and I lost my footing, and that's when I fell.
Was there a manager on duty who might be able to help?
There was a manager on duty that night.
How did she respond?
Once I'd made it back inside, she just responded that the stairs were something they knew they should have fixed, but other things were more important, and that she was sorry.
Ms. Gilmore, I'd like to just clarify a couple last points. Had anyone told you not to go out back?
No.
Had anyone ever instructed you that doing so was unsafe?
No.
Had anyone told you that someone other than the Chimes or than Chimes department store was responsible for this area?
No.
Did you have any reason to think someone other than Chimes department store was responsible for this area?
Objection, Your Honor, to relevance, if I may be heard.
Go ahead.
This witness's understanding of who owned or operated the outside area doesn't make a fact more or less likely. There's an objective standard as to who owned or operated the area, and not what this witness believed to be true.
Overruled. Go ahead. Proceed.
Your Honor, may I just re-ask that question for clarity?
It's up to you. You may.
Ms. Gilmore, did you have any reason to think that someone other than Chimes department store was responsible for this area?
No.
Your Honor, we passed the witness.
Cross-examination?
Yes, Your Honor.
Go ahead, you may proceed.
Thank you, Your Honor. Good morning, Ms. Gilmore.
Good morning.
Those stairs that you just told us about, you've used them thousands of times.
About 20 times a week, 10 years.
Right, you worked there for 10 years, right?
Yes,
At the same store,
yes,
and every day you would use those stairs.
yes,
You would go down those stairs to take out trash,
yes,
down those stairs to take a smoke break, right?
yes,
And you would go back up those stairs to get back to work.
yes,
All 10 years you've been working there, those stairs have been the same.
yes,
The same loading dock,
yes,
the same number of lights,
yes,
and on the day that you were injured, everything on that loading dock was the same as always.
Riley holding the door, I think, would be the only difference. But other than that, yes.
But what you did, ma'am, that day was different.
How so?
Well, we'll talk about that, ma'am. But first, Mr. Beachy, could we have Exhibit 17, please? Your Honor, this is pre-admitted. You see this right here? This is Exhibit 17, right?
Yeah.
Not on the full screen, is it?
Yeah,
On?
I can't really see it. I'm sorry.
Those look like the stairs that you climbed up every day for 10 years, right?
Yes.
Now, there are two sides to that stairwell, right?
Yes.
Well, one is on the wall, right?
Yes.
The other is on the edge.
Yes.
You know that when you walk down the wall, you can hold on to that wall, right?
Yes.
You can't fall off of the side of the stairs on the side of the wall, right, ma'am?
Yes.
But on the other side, you know that you can fall off the edge, right?
You could, yes.
Now, when you walked down the stairs that night, you had no problem getting down, right?
Yes, correct.
But when you walked up the stairs, you walked up the other side, right?
Yes, to get around the door.
You walked up the other side with the edge, right?
Yes.
The side you knew you could fall off of.
Yes.
And the reason, ma'am, that you walked up the other side, as you just said, was because of that door blocking your way.
Yes.
Your Honor, permission to show a demonstrative for the members of the jury. We showed this to opposing counsel, and he had no objections.
Counselor, did you have any objection?
No, Your Honor.
You may.
Ma'am, this is a diagram of the loading dock, right?
Yes.
You can see the steps on the right,
Yes.
that door that we were just talking about, right?
Yes.
And then the loading portion on the left.
Yes.
Now, this accurately reflects what the loading dock looked like on January 23rd, right?
Yes.
Now, on that night, the door was halfway open, just like it's shown in this diagram.
Yes.
That meant that the door was blocking your way up the stairs.
Yes.
Mr. Beachy, could you highlight the portion of those stairs that wasn't blocked by the door? So that's the part of the stairs, ma'am, that you chose to walk up. Right?
Maybe I'm confused by the diagram. Is the door actually pictured on this, or is that a wall?
That's right, that's the door.
And it's
The door's right there in the middle. It was opening up and blocking your way. In fact, let's get a photograph of that day. Your Honor, we're showing already entered Exhibit 3. You see that, don't you?
Yes.
That's where the door is actually blocking your way.
Yes.
Mr. Beachy, could we highlight those stairs? Ma'am, that's inches of space that you walked up.
Yes.
To be clear, ma'am, your department store didn't ask you to walk up those inches of space, right?
No.
So let's take a look at Exhibit 5 again. That door, as you know, it doesn't have to block your way, does it?
No, it doesn't have to.
It can open all the way.
It could, yes.
I'm showing you for demonstrative purposes that door swinging open. That's sort of what it looks like. Isn't that right, ma'am?
Yes.
And when that door swings open, You can walk all along that staircase, right?
Yes, when it's open like that, yes.
Mr. Beachy, could you highlight the stairs, please? You would have that whole portion of the stairs to walk up, right?
Yes.
You wouldn't have to go over the edge like you did on January 23rd, right?
Yes.
Ma'am, instead, you chose to walk up those couple inches, didn't you?
Yes.
That's when you lost your balance, right?
Yes.
And when you started to lose your balance, well, your friend Riley, she reached out a hand to try to help you, right?
Honestly, I can't really recall that just because I was falling. So I don't really remember what was happening what she was doing at that time.
Ma'am, you don't remember your friend reaching out her hand to help you?
As I was falling backwards, no.
I'm sorry, could you repeat that?
Yeah, as I was falling backwards, no, I don't remember that.
Would you like your memory refreshed, ma'am?
Sure.
You remember sitting down for deposition?
Yes.
And you would recognize that deposition if I showed it to you today?
Yes.
Your Honor, permission to screen share the witness's deposition to refresh your recollection.
You may.
Ma'am, this is your deposition.
Yes.
It's a fair and accurate copy of that deposition, right?
Yes.
All right, let's turn to the line, ma'am, and just read silently and let me know when you're done reading the highlighted portion.
Okay, I'm done.
All right, so you remember that your friend Riley, she reached out her hand, right?
She did.
But you didn't try to take her hand.
No, it was too late.
But ma'am, instead you jumped, didn't you?
Yeah, it was too late to take her hand, so I jumped.
But that's a yes to my question. You jumped, right?
Yes.
You jumped off of those stairs.
Yes.
Chimes department store certainly didn't tell you to jump off of those stairs.
No.
Chimes department store certainly didn't tell you to leave that door halfway open.
No.
Chimes department store didn't tell you to walk up just a few inches of those stairs.
No.
Those were your choices.
That was what was available at the time.
Your choices, ma'am.
The only choice. So yes, it was my only choice.
Thank you. Your Honor, I pass the witness.
Okay, before redirect, Tom and Sarah, they want us to have y'all turn off your cameras, if y'all don't mind.
Wait, all of it?
Okay. Any redirect?
Yes, Your Honor.
You may proceed.
Ms. Gilmore, I have just a couple of brief questions for you. Now, on cross-examination, you mentioned that there were a lot of things that Chimes never told you to do. I want to ask a couple more questions about that.
Okay.
In your 10 years of working at Chimes, did anyone ever instruct you that there were certain parts of the stairs you shouldn't use?
No.
In your 10 years at Chimes, did anyone ever instruct you on how to position the door at the back near the loading area?
No.
In your 10 years at Chimes, did anyone ever tell you that what you were doing was against the rules?
No.
And finally, in your 10 years at Chimes, did anyone ever tell you that what you were doing was unsafe?
No.
No further questions.
Anything further from the defense?
No recross for this witness, Your Honor.
Okay, plaintiff, call your next witness.
Your Honor, at this time, the plaintiff would like to call our expert witness, Kelly Danes, by way of deposition pursuant to Federal Rule of Evidence 804A. Permission for my co-counsel Mr. Haddon to share his screen and read with me the responses to a few line items.
That's fine. You may proceed.
Mr. Haddon, if you could just start at page 80 of the record, and we'll read lines 12 through 14.
Can you all hear me?
We can hear you.
Great. Ms. Daines, tell us about your education.
I have a bachelor's of science in mechanical engineering from the University of Wisconsin-Madison.
Since graduating from college with your mechanical engineering degree, you've gotten further education.
Sure, I've attended various seminars offered by the National Academy of Forensic Engineers. I took the courses to become a certified person builder from the Scaffold Training Institute, and I took the requisite courses to become certified in ASME B31.3 process piping design from the American Society of Mechanical Engineers. So basically some continuing education and additional certifications.
Now I noticed that your CV lists you as a PE. What is that?
It stands for professional engineer.
Now we're going to move on to page 81 of the records, lines 13 through 21. What do you do professionally?
I'm the president of Daines Engineering, LLC.
What does your company do?
We provide forensic and investigative engineering consulting and litigation support, specializing in industrial, commercial, and construction engineering, operations, safety, patents, and regulations. So basically, we help to investigate engineering issues in those fields throughout the United States, mostly connected to lawsuits just like this one.
I'll now direct your attention to page 82 of the record, lines 14 through 20. Over the course of your career, how many incidents have you investigated?
Over 60.
How many times have you been deposed?
About 20.
And how many times have you testified at trial?
Twice prior to this.
Now I'll direct your attention to page 86 of the record, lines 16 through 20. Okay, what opinions have you come to in this case?
First, the International Building Code and the regulations from the Occupational Safety and Health Administration apply to the stairs and landing in question, and the facilities in question must be in compliance with those codes and regulations.
Now I'll turn your attention to page 87 of the record, lines 9 through page 90 of the record, line 24. All right, so which portions of the IBC codes and the OSHA regulations did you find important in this case?
First, the general duty clause in the OSHA regulations, which can be found in 29 USCS section 654, and the maintenance provisions under section 3401.2 of the IBC.
What are those, why are those significant in this case?
These are general provisions that require an employer and or the party that is responsible for maintaining a building or structure to keep that building or structure in a safe and well-maintained condition, free from recognized hazards. Here, as you can see from the photographs that I took during my investigation of the stairs, the broken off concrete, the lack of stair railings, the lack of railings on the platform, the door blocking the pathway, and the lack of a light switch to turn on the light above those stairs were all hazards that should have been identified with a simple and effective safety program. But the defendant didn't have such a program and never identified or corrected these hazards, so fairly clearly, the defendant violated these requirements under both the IBC and the OSHA regulations.
Objection, Your Honor, to an improper legal opinion. May I be heard?
You can be heard.
The witness is testifying now to what's in the province of the jury, whether the defendant actually violated a given statute or law. Certainly, the witness is an expert and can testify to his expertise, but he can't testify to what the jury decides. That's exactly what he's doing.
Response.
Yes, Your Honor. This is an expert opinion. It's not the jury's opinion, it's the expert's opinion. And the jury is entitled to know what the expert believes. The expert is allowed to opine on the underlying evidence and the conclusions that he came to. And the jury is able to take this information and as the trier of fact to determine how much weight and credence they intend to give to it. And of course, opposing counsel has every opportunity to argue otherwise.
Overruled. Proceed.
Now we'll go to page 91 of the record, starting at line 4 through 15. Great. And we will mark that photograph with your markings as Exhibit 35. Do you know when the guardrails were removed from those stairs?
No, and I don't know who had them removed. All I know is that at one point they were there, and by the time this incident took place, they were gone.
Couldn't a person walking up those stairs have just used the wall to steady themselves and stayed away from the exposed edge of those stairs?
I mean, I suppose that would work, but that's not the question. The bottom line is that those stairs needed guardrails in order to meet code requirements, and they didn't.
No further questions, Your Honor.
Do you have anything for this witness?
Yes, Your Honor, permission to read a line from the witness's deposition onto the record.
You may.
Question. Do you know or have any opinion on who was responsible for the maintenance and repair of these steps behind the Chime store? Answer. No, that's not what I was asked to do. That's all, Your Honor.
Your Honor, may this witness be excused?
Yes.
At this time, Your Honor, the plaintiff rests its case in chief.
Okay. Defendant, do you have any witnesses?
Yes, Your Honor, but before proceeding to defense case in chief, we would have a motion for Your Honor.
Okay. You want it outside the presence of the jury?
Yes, Your Honor.
Well, they're constructively outside right now. Go ahead.
Yes, Your Honor, thank you. We move for judgment as a matter of law under Rule 50. The plaintiff hasn't produced enough evidence for a reasonable juror, even viewed in the light most favorable for the plaintiff, to find for the plaintiff when it comes to cause. They haven't shown actually a duty either, that the plaintiff actually suffered injuries and that the defendant owed them a duty of care. In fact, we've shown that another party, that Kermit Realty Group, was actually the party who had control over the loading dock area, who actually owed the plaintiff a duty of care. So we ask for a judgment as a matter of law on that issue.
Response.
As Your Honor is aware, a Rule 50 motion must be looked at in the light most favorable to we, the plaintiff. We simply needed to present enough evidence for this jury to find a legally sufficient evidentiary basis to find for the plaintiffs on the issue of Chime's department store's negligence. And that's exactly what we did. To find that Chime's subjected Ms. Gilmore to unreasonable risk that were foreseen, the jury can rely on testimony from our expert and also from our witness, Jordan Gilmore. Now, Jordan Gilmore speaks about the lack of a guardrail that Chimes actually had removed. She talks about the pitch black surrounding of the loading area, which led to stairs on the loading area being barely visible. The manner in which Chimes showed control over her behavior and the activities that took place in that loading area, such as dictating that this is where employees had to smoke and dictating this is how employees had to take out the trash. They can also rely on testimony from our expert witness, Kelly Daines. Through OSHA regulations, she provides context of the relevant standard of care. Therefore, looking at this evidence and the light most favorable to we, the plaintiff, there is a sufficient evidentiary basis for the jury to find for Chimes, or to find that Chimes is liable. for negligence.
All right, I'm going to deny the motion for directed verdict. Do you have any witnesses you want to call defense?
Yes, Your Honor, we would ask for a 5-minute recess before defense witnesses.
We'll take a 5-minute recess. Court's at recess. Everybody back in 5 minutes, please. right, are we ready to proceed?
Yes, Your Honor.
Call your first witness.
Your Honor, we call Reese Geller to the stand. May I inquire?
You may.
Good morning, ma'am. Could you please introduce yourself to the members of the jury?
Good morning. My name is Reese Geller.
And Ms. Geller, where are you calling in from?
I'm in Waco, Texas.
And what do you do for a living?
I own a department store called Chimes.
What kind of store is Chimes?
Chimes is kind of like a really small JCPenney. You can buy home goods or tools, anything you want, clothing.
And who started that store?
My grandparents did, and it's been in the family, so it got passed to my parents, and now they passed it to me.
How long have you worked at that family store, ma'am?
I've worked at Chimes since I graduated college in 1988, and it's been my only job.
How long have you been the owner?
I became the owner 10 years ago.
I'd like to talk about your building. Is Chimes the only store in that building?
No, so I actually have two other businesses that we share the building with.
You say that you have those two other businesses, ma'am. Do you own those businesses?
I do not.
So do you own the building that those businesses are in?
No.
Who does?
We have a landlord, Kermit Realty.
Do you have a lease with Kermit Realty Group, ma'am?
Yes, I rent from Kermit, and we have a lease that was executed in 2005.
Your Honor, I'm showing the witness and opposing counsel, as well as the members of the jury, what's already been in evidence as Exhibit 11. What is this, ma'am?
That's my lease with Kermit Realty.
Ms. Geller, I'd like to start with Section 1.10 of the premises. According to that lease, did you lease out the entire building or just part of it?
Just part of it.
How did you know which part that you were leasing it?
They provided a map which showed which part of the premises was mine.
Well, let's look at that map. If we could get the last page of Exhibit 11. Thank you. Ma'am, do you recognize this?
Yes, I do.
What is it?
That is the map of the building.
I know there's a lot going on here, ma'am. Your Honor, permission to display this image without the text for demonstrative purposes?
Any objection?
No, Your Honor.
You may.
So let's start by focusing on the bottom half of the map. What's this section with all the lines on it there?
That's the parking lot for the three businesses.
Under the lease, do you rent out any part of that parking lot?
Yes, I do. I rent out just the middle section.
I'm highlighting the middle section of the parking lot in blue here. Is that the area you rent?
Yes, it is.
What about to the right and to the left of the Chimes parking lot?
No, that is the parking lot for the other businesses inside the building.
Moving to the top half of the map, ma'am, what are those rectangles?
Those are the three businesses inside the building.
Could you explain where Chimes is located?
Chimes is right in the middle.
I'm highlighting the middle box. Is that the area that you rent?
Yes.
But what's to the right and to the left of the Chimes building?
Just two other businesses.
What about the area above the building? What's that?
Oh, there's an alley right there.
To be clear, ma'am, is that alley a part of your lease?
It is not.
We've heard a lot of testimony about a loading dock. Now, where is that loading dock on this map?
So the loading dock is in the alley behind my store.
Mr. Beachy, could we get a mark for that loading dock? Ms. Geller, does this mark accurately reflect where the loading dock is?
Yes, it does.
Ma'am, is the loading dock inside or outside of the area you rented in your lease?
It is outside.
So if the loading dock was outside your lease, Let's take a look at whose responsibility it was. Mr. Beachy, could we have section 6.1 on the screen? Ms. Geller, could you read the highlighted portion for the members of the jury?
The term common area is defined for all purposes of this lease as that part of the shopping center intended for the common use of all tenants, including alleys and loading areas.
So according to your lease, was the loading area behind the building where the plaintiff got hurt? Is that a part of your store or the common area?
That would be a part of the common area.
Then can we get section 6.3? Could you read that, Ms. Geller?
Yes. Landlord shall be responsible for the good and safe operation, management, and maintenance of the common area.
Based on that section, who did you understand to be responsible for the safety of the common area, like the loading dock?
I understood that it was Kermit Realty's responsibility.
Thank you, ma'am. Your Honor, pass the witness.
Cross-examination.
Yes, Your Honor. Ms. Geller, I'd like to start by discussing what you do for a living. Now, you mentioned on direct examination that you're the owner of Chimes Department Store.
Yes, I am.
You also mentioned it's located right here in Waco, Texas.
Yeah, family-owned small business.
Working at Chimes is what you've done your entire career.
Yep, I'm keeping it going. Hopefully my kids will have it too.
You started out as a buyer,
Oh yeah, definitely the bottom of the totem pole.
and now you're the boss.
Since 1988, so 12, 11. I think I earned it.
And that's not too surprising.
Hopefully not.
I just mean to say that Chimes is a family business started by your grandparents.
Yes,
And like you mentioned, you've been the boss for 10 years.
I have.
Let's talk a little bit more about Chimes. Chimes is a department store.
Yes.
You sell shoes,
Mhm.
clothes,
Yes.
even tools,
All the things.
among other things.
Mhm.
Now, in 2005, Chimes moved to the location that you're at right now.
Yes. We needed a bigger.
You needed more space.
Mhm.
Now, you actually helped negotiate the current lease with your landlord, Kermit.
Yeah, I helped just a tad.
So you're aware that according to the lease, and you mentioned this on direct, there are certain areas that you have access to, but not necessarily control over.
Yes, that's right.
These areas that you do have control over, there are areas that you do have control over as well.
Yes.
And those areas are called demised premises.
Mhm.
And you just actually talked through a site plan that specifies which areas are and are not under your control.
Yes, I have my store and my little parking lot.
Now, I'd like to talk to you about the area behind Chimes. Referring court and counsel to what's already been admitted as Exhibit 2. May we publish?
You may.
Now, the loading dock and the surrounding area that you see in this picture, they were not a part of the demised premises.
No, they're not.
So according to the lease, they were under the control of the landlord.
Yeah, that's right.
But you'd agree that Chimes had some control over that area.
Well, we could request to make changes to that area, but it was ultimately the landlord's decision.
Well, isn't it true that Chimes ordered a dumpster?
Yeah,
The dumpster in that photo, actually.
yeah.
And you didn't get your landlord's permission to do that,
No.
even though that area is specified as under the control of your landlord.
But we can still use it because it's common area.
And so again, you never even let them know about the dumpster that you placed there.
No, I don't think I had to.
Now, there were no guardrails on the steps around that area?
There was initially,
There were initially, but then you had actually asked your landlord to remove them.
yes.
You never reached out to Kermit and asked them to put guardrails next to the stairs.
I'm sorry, what was that?
You never asked your landlord to put guardrails next to the stairs.
So there was a guardrail originally around the stairs and the loading dock, and we requested to have the guardrails removed so that we could actually load products into the store.
Right. And you never actually asked them to at least put the guardrail next to the stairs back.
No, I think, well, in order to load, we would have to back up, and so the guardrail would be in the way.
Well, I'm talking about next to the stairs where people were walking, not loading. You never asked anyone to put a guardrail next to the stairs, apart from the loading area.
Objection, Your Honor, to asked and answered.
Overruled.
No, because we have to load it, and so the doors have to open, there has to be room, and so the guardrails are just not feasible.
Ms. Geller, is it your testimony that you load items over the stairs?
I mean, the stairs are connected to the loading zone, so possibly.
Possibly.
Possibly that the loading truck or doors may extend overhead of the stairs.
Now, I'd like to talk to you about the area, or more specifically, I'd like to discuss how Chimes responds to safety issues. Now, you instruct your employees to let you know if there are any safety issues.
Yes, I sent an email letting them know.
And you do this because you care about your employees.
Yeah, definitely.
Now, you actually did have an employee report some issues of safety that they discovered around the loading area.
Which ones?
Referring court and counsel to what has been marked as Exhibit 14 for identification, let the record reflect. Opposing counsel has a copy of Exhibit 14. Ms. Geller, do you have a copy of the case file in front of you?
Yes, let me pull it up. You said 14?
Yeah.
Okay, yes,
Now you recognize this.
I do.
You recognize this because this is a report that was made by one of Chime's employees.
If the court, please, is this the subject of if this is the subject of the motion in limine?
Yes, Your
Yes, Your Honor.
What I thought. Okay. I had an order on that motion, if I recall correctly, right?
Yes, Your Honor.
Yes, Your Honor. It was my understanding that.
Excuse me. I granted the motion in limine, did I not?
Yes, Your Honor.
So there's an order in limine, correct?
Yes, Your Honor. If I may, Your Honor, it was my understanding that that order was not made with prejudice. I believe that you had mentioned that we had have the opportunity to.
I understand that, but isn't it your responsibility, counsel, to not mention it before in front of this jury before addressing it with me? I think that's your responsibility, right?
Yes, Your Honor.
All right, and you went right into it, right?
Well, Your Honor, I'd hope not to actually publish it before discussing that with yourself and opposing counsel, but I understand it's your preference that I actually step outside the presence of the jury to even lay the foundation, and I can do that if Your Honor permits.
Well, Your Honor, may I be heard?
Let me introduce it. Ladies and gentlemen of the jury, you're to disregard everything that has been discussed, starting with the question that was asked regarding Exhibit 14 of this witness. Now I'm going to grant your request to discuss this outside the presence of the jury.
Yes, Your Honor.
Like, you don't need to be bringing up something that an order in limine is on without, you've got to be abundantly cautious about that. So you can address it now.
Yes, Your Honor.
What's your argument?
Your Honor, this witness has just testified that she has instructed her employees to alert her to any issues of safety, that she cares about her employees' safety. And because this goes directly to a standard of care that this defendant has established among her own employees, that they should be alerting her to issues of safety, presumably so she can respond to them. It is highly relevant that this defendant was placed on notice because of an instruction that she gave to her employees.
Response.
Your Honor, the question is not of relevance here. There's an improper character evidence under 404 and a hearsay within hearsay under Rule 805. We now know that this area is not even controlled by Chime's department store. It's controlled by the Realty Group. So counsel's argument that this goes to the knowledge of the defendant actually doesn't hold water, because this goes to the negligence of a third party. It goes to the negligence of Kermit Realty. We ask that this be excluded.
I'm going to give you very limited leeway to march down this path.
Yes, Your Honor.
You can proceed. I'm going to overrule the objection. I'm going to allow you to proceed, but I'm going to caution you that be very careful. Members
Yes,
of
Your
the jury, members of the jury, I'm going to instruct you now that the evidence that you're going to hear with respect to Exhibit 14 is solely and only for the purpose of the issue of whether or not Chime had notice of some issue prior to this incident. Notice only. It is not admissible and not relevant to for any other purpose in this case. You are so instructed. Proceed cautiously.
Yes, Your Honor. Oh, Ms. Geller, do you have Exhibit 14 in front of you?
I do.
Now, you do recognize this.
Yes.
And you recognize it because this is a report that was made by a Chimes employee.
Yes.
They reported a safety issue that they encountered in the back of the Chimes department store in the loading area.
Yes.
And this is an accurate copy of that report that was made.
It is.
Your Honor, plaintiff moves Exhibit 14.
May I be heard, Your Honor?
You may.
There are still those hearsay issues that Mr. White hasn't addressed. In fact, under Rule 805, it's hearsay within hearsay. Notice gets over one layer of hearsay, but not both.
Your Honor, may I reply?
You may.
Your Honor, as I mentioned in motions in limine, we won't be asserting anything in either layer of this document as being true. And we won't be arguing anything in this document for the truth of the matter asserted. And we do intend in closing arguments to stipulate the limiting instruction that you just gave the jury.
Okay, I'm going to allow it into evidence.
Now, Ms. Geller, you're aware that Mr. Stiles, he's the one that actually submitted this report.
Yes.
Mr. Haddon, could you publish Exhibit 14 for us? Now, Mr. Stiles reported that the loading area was dark.
He did.
You're aware that he asked about a light switch?
Yes.
And you're also know that he was told by a supervisor that the light switch was next door and nothing could be done about it.
Mm-hmm.
He
Yes.
says he was walking down the stairs when he fell face first.
Um, yes.
And he noted that there was nothing for him to grab onto.
No.
It's your testimony that he does not mention that there was nothing for him to grab onto?
Oh, I was agreeing that.
Oh, okay. So you were made aware of these concerns on January 8th, 2010.
I'm not sure when I received notice.
Now, regardless of when you received notice, you didn't address these concerns.
No, because the outside's not my property. I don't rent it, and it's not under my control.
Thank you, Mr. Haddon. Now let's talk about your current workers. Your workers were familiar with the area behind Chime's department store.
Yes,
They use that area a lot
every day.
because they needed to use it.
Yes,
They needed to use it to do their job.
they did.
They receive deliveries there almost daily.
Every day, yeah,
They also use this area to dump trash.
they do.
You'd agree that you're responsible for your employees.
I am responsible for my employees.
You're in charge of their work.
Yep. But I'm not in charge of the loading area.
And you have a responsibility to ensure their safety.
Definitely. I want my employees to be safe.
But Chimes never inspects anywhere inside or around the store for safety issues.
I mean, none come to my attention, and inside the store, I don't really think there are any. And if there are, we would definitely address them.
Well, you leave that responsibility with your employees.
No, I don't. I think it's more of like a shared responsibility. Like if I see it, I'll fix it. If they see it, they need to notify me.
It's your testimony that you don't leave that responsibility with your employees.
I said concurrently. It's a concurrent responsibility.
So it's your testimony that it's not your employee's responsibility, it's a concurrent responsibility.
Yes, I have a responsibility as well as my employees, as we all work there.
Now, you've made statements about how Chimes regards safety in the past. Isn't that right?
I don't know what you're talking about.
Well, you've taken a deposition in this case. Isn't that right?
I did.
And in that deposition, you swore to tell the truth.
And nothing but the truth, yes.
Because you understand how important it is to tell the truth.
I do. I always tell the truth.
Especially when an employee has been injured.
Yes, I have been telling the truth.
Referring court and counsel to Ms. Geller's deposition on page 104 of the record, lines 9 through 15. And I see you've published that, opposing counsel. I'm going to start reading at line 9, and I'm going to end at line 15. Ms. Geller, feel free to read to yourself as I read aloud. Question. Let me ask you this. Does Chimes regularly inspect the premises in or around its store looking for safety issues? Your answer, no, we're not a safety company. We're a department store, so we wouldn't even know what we should be looking for. However, we do instruct our employees that they should always be on the lookout for safety issues as part of their job duties and alert us if they see anything that worries them. Did I read that correctly?
Objection, Your Honor. Hearsay to an improper impeachment. May I be heard?
I'll give you a moment. Yes.
There has been no contradiction between what the witness just said on the stand and what Mr. White read from her.
I don't need to
deposition.
hear anything further. I don't need you testifying. I just need to know if you had an objection. And that whatever that objection was is overruled. You can answer.
I'll ask that again, Ms. Geller. Did I read that correctly?
Yes.
No further questions.
Redirect.
Yes, Your Honor. Ma'am, on cross-examination, Mr. White asked you some questions about that back loading dock. asked you some questions about a prior instance of someone getting hurt. Do you remember that?
Yes.
Who was in control of that back loading dock when that person was hurt?
That would be the landlord, Kermit Realty.
Whose responsibility was it to maintain that back loading dock when that person was hurt in 2010?
Kermit Realty.
And ma'am, whose responsibility was it to maintain that loading dock in 2019 when the plaintiff was hurt?
Kermit Realty.
Thank you, ma'am. Pass the witness.
Call your next witness.
Your Honor, we have no further witnesses. We rest our case. We ask for a brief 5-minute recess before closing arguments.
Okay, give me 2 seconds before we take that recess so I can give you some totals in terms of time. Give me a second. All right, my mathematics is not that great, but right now I have the plaintiff at 38 minutes, 11 seconds, and the defense at 21 minutes and 23 seconds. Understand that the seconds are not as precise as I would hope they would be. And I did not take away time or give anybody time for any arguments on any objections that we had. Okay, so that's what you have remaining for your closing. Everybody got that?
Yes, Your Honor.
Yes, Your Honor.
All right, I'll give you a 5-minute recess and then we'll go through closing. All right, whenever you're ready, proceed with the closing argument.
Convenience first, safety second, responsibility last. The defendant, Chimes Department Store, had a railing removed from around the concrete platform and stairway behind their store. This made things easier for them to access and load merchandise. Convenience first. Then they ordered their employees to take their smoke breaks behind the store in the dark on the concrete platform using the stairway with missing railings. Safety second. On January 23rd, 2019, my client, Jordan Gilmore, fell off these stairs while taking a smoke break, lost her balance, and landed on her backside. Because in Chimes Department's eyes, their pocketbook, their responsibility comes first. Jordan Gilmore is a simple person with simple needs. Today, she isn't asking for anything extraordinary or even anything out of the ordinary. You see, she just worked as a cashier for Chimes Department Store. It's not the type of job anyone would consider especially risky or dangerous. A typical day for a cashier includes scanning some barcodes, filling up a cash register, taking out some trash. She never expected that something as simple as taking a break would leave her broken, out of a job, and in court, begging for the defendant to just take responsibility. So today, Jordan Gilmore has brought suit against Chimes Department Store for negligence. Now, negligence is somewhat of a fancy legal term, but at its heart, negligence is really about the relationship that we have as a society with each other and the responsibility that comes with it. The defendant has a responsibility to act in a reasonably careful manner towards their employees. And their failure to do so led to Jordan Gilmore's fall. We only need to prove this by a preponderance of the evidence. A helpful way to visualize this is to consider an arm wrestling contest. For Jordan to win today, she doesn't have to slam Chimes' hand down on the table. She doesn't have to struggle with them until they give up. She doesn't even have to make them scream uncle. She merely needs to move their fist slightly to the left, cause the grip to slip until it barely moves enough to notice. This isn't a burden we shy away from because we've already met it many times over. So let's start by breaking down this question of negligence into three simple questions. First, did the conditions that led to Jordan Gilmore's fall pose an unreasonable risk of harm? Second, did Chimes Department Store know or should they have reasonably known of the danger? And third, did Chimes Department Store fail to exercise ordinary care to protect Jordan Gilmore from that unreasonable risk of harm? To determine whether Jordan was subject to unreasonable risk, we simply need to ask ourselves, given everything we know about Jordan and the type of work she did, is the harm she suffered something you'd expect? Well, let's break this down. Jordan Gilmore wasn't a warehouse worker. She didn't work in a position that required any special safety training, wasn't responsible for loading or unloading delivery trucks. Jordan Gilmore was just a cashier. Despite this, Jordan was expected to go up and down concrete stairs with no railing to hold on to in pitch black conditions where the ash from her cigarette provided more light than a lamppost. The only person willing to tell you that that was reasonable is the person who has everything to lose. These conditions weren't kind. They weren't careful, and they weren't considerate, just convenient. Members of the jury, the next question you'll be asked to answer is whether Chimes' department knew or should have known of the danger. Not only did Chimes know about the danger, they were really on notice about this danger. During cross-examination, Reese Geller, the owner of Chimes' department, admitted that she knew that some of these dangers existed. You can't have it both ways. Where I'm from, someone would look at this and say, pick a struggle. Either admit your decision to remove the guardrails was bad judgment, or that you were the only person interested in making decisions that made your life convenient at the cost of everyone around you. The dangerous conditions that Chimes created for its workers were generally known by everyone. After Jordan Gilmore fell down while attempting to climb barely visible stairs, the first thing the manager on duty, Lane Kim, says is, Chimes should have fixed those stairs a long time ago. This is an admission that this environment was just unsafe. It was broken. Chimes knew about it, and they didn't care. The final question on this issue of negligence that you'll be asked to answer is whether Chimes failed to exercise ordinary care to protect Jordan Gilmore. Ordinary care simply means that anyone else in the same or similar circumstance would have exercised the same level of care. Well, Jordan Gilmore trusted Chimes to do what they could to keep her safe. Not just because it's the right thing to do, but because that's what they said they would do. During my cross-examination of Reese Geller, well, she told us that she instructed her employees to let her know if there were any safety issues because she cares about their safety. But we found out that was a lie. I'm going to ask my co-counsel, Mr. Haddon, to pull up Exhibit 14. We learned about a report that was made 9 years before Jordan Gilmore's fall. The statements on this report were made by an employee named Jason Stiles. Mr. Stiles alerted Chimes to conditions he felt were dangerous. Not only does this show that Chimes had notice of dangerous conditions on their property, it shows failure to exercise ordinary care. This evidence is important because it put the defendant on notice of conditions that made this area unsafe for their workers. Mr. Stiles said that back area was dark, but for 9 years, Chimes didn't turn on any lights. Mr. Stiles said he slipped on what he believed were the stairs, but for 9 years, Chimes didn't repave that stairway. Mr. Stiles said he fell face first because there was nothing to grab onto. But for 9 years, Chimes didn't reinstall a guardrail next to the stairs. In fact, Ms. Geller jokingly laughed about not even knowing if packages needed to come over the stairs during unloading times. She didn't want to admit that there was no reasonable excuse not to have a guardrail next to stairs that obviously would not be needed to unload delivery trucks. 9 years of incompetence, 9 years they knew, 9 years of convenience. During your jury deliberations, you're going to have the opportunity to review the testimony of our expert witness, Kelly Daines. Kelly Daines is a professional engineer with a degree in mechanical engineering. She's got a background in investigating and engineering issues. In her testimony, she talks a lot about the Occupational Safety and Health Administration, also known as OSHA. You see, OSHA sets safety standards that in cases just like this help us determine the standard of care. And what you'll learn is that OSHA standards apply to stairs just like the ones Jordan was walking up when she fell. OSHA requires that these types of areas be properly lit and that the stairways have guardrails on all exposed sides. This was their standard of care, and they knew it was their standard of care. It's why they told their employees to let them know about safety issues that they found. Chimes breached their standard of care, failing to act on issues that they were alerted to by failing to incorporate standards set by OSHA. And their counsel has come to court today and spent a lot of time trying to place the blame on other people. They've placed so much blame, I had to write down some of the things they said so that I wouldn't keep track. Opposing counsel blamed Jordan Gilmore for losing her balance. They blamed her for jumping after she fell to try to stand on her feet. They blamed her for missing her friend's hand as she was falling. They blamed her for the positioning of the door. Mind you, all of these things were conditions that their client caused. Opposing counsel also spent some time talking about the wall next to the stairs. See, she asked Jordan Gilmore about why she didn't keep her hand on the wall as she was walking up the stairs for balance. Apparently, that is what Chimes expects its employees to do. If you're walking up those stairs, your hand needs to be on the wall. So then what happens if you got something in your hand like trash? Trash in one hand, the other hand on the wall? This is a circus act. This is the kind of thing that you would expect at the circus, not at a place of work. Opposing counsel is going to stand before you momentarily, and they're going to try to convince you of some of these same things, convince you that what happened to Jordan Gilmore is someone else's fault, or maybe even that it's no one's fault. After all, according to them, the area where this accident occurred isn't even under Chimes' control. Now, that's a lie that they're going to put a lot of energy into, trying to sell you. So let's talk about it now. When they tell you that they couldn't put up a guardrail or attach a lamp to their building because that area was outside of their control, that argument is trash. And yes, I'm referring to the massive dumpster they placed in that same area. Not only did they not get permission to do so, they never notified their landlord. So is it that Kermit only had control over the loading area when Chimes is trying to avoid responsibility? Well, the answer is yes. Now, even if we do accept the rationale that Kermit was in control of the loading area and not Chimes, Kermit doesn't make Chimes employees walk around in the dark of night. Kermit doesn't make Chimes employees step on barely visible stairs with no guardrail to take out the trash. Kermit doesn't make the loading area the designated location for smoke breaks. Even if Chimes isn't responsible for these dangerous conditions, they're liable for knowing about them and sending their employees there anyway. Mr. Haddon, could you publish the jury charge? Members of the jury, momentarily you're going to be given some instructions, including this jury charge. You're going to be asked to determine if Chimes proximately caused Jordan Gilmore's fall, or in other words, if their actions or failure to act led to the January 23rd incident. Based on all of these facts that have come out through the course of this trial, the answer to that question is a resounding yes. The level of carelessness and control they exercised over the loading area and their employees makes them 100% liable. Now, at some point, we need to say enough is enough. When you hire someone to do a job, when you tell them how to do it, when you tell them where to do it, and you don't get to make disingenuous loopholes to avoid liability. Everyone has to answer for their decisions, for their choices, but Chimes doesn't agree. Tell the defendant that they can't choose convenience first. Tell them that they can't place safety second. Tell them that they can never put responsibility last. Hold them liable.
Defense?
Yes, Your Honor. May it please the court. You know, members of the jury, as Mr. White was speaking right then, I couldn't help but nod along. I couldn't help but agree with many of the things that he told you. That's because you've seen again and again the plaintiff and the defense. There's actually not much that's missing between us. We agree that the right person should be held responsible for maintaining that dock poorly. We agree that the right person should be held responsible for hurting the plaintiff. Members of the jury, that person, that entity is not the defendant, not Chimes Corporation. It's Kermit Realty. Because as you learned today, Kermit Realty was the party that had control over that dock. Kermit Realty was the party that could change elements of that dock, and Kermit Realty, not Chimes Department Store, had the power to make sure that the plaintiff was safe. Ladies and gentlemen, the plaintiff had a duty to prove to you otherwise. They had to show you 4 things more likely than not. First, that Chimes had a duty to the plaintiff. Second, that they breached that duty. Third, that the plaintiff suffered injuries. And finally, that those injuries were the direct and proximate cause of her injury. They failed to meet that burden today. They failed to even meet the first element of that burden. Now, the first element of that burden is duty, and I want to talk to you about that, members of the jury. And now, a part of that element of duty, the judge will instruct you that the person has to have control over the area. You'll see the jury instructions here. Mr. Beachy, could we get those jury instructions, please? You'll have this to take back with you to deliberations. These jury instructions, well, they say that Chimes can't be held liable for something that they don't have control over. It says that party must have had control over the area in which the injury occurs. A control can be proven by either a contractual agreement or an actual exercise of control. And ladies and gentlemen, we showed you a contractual agreement between Kermit Realty and Chimes. Could we pull that up, Mr. Beachy? This is that agreement. You'll have that with you in deliberations as well. We've been talking all day today, members of the jury, about the common area. The common area back there at that loading dock. And this lease couldn't be more clear as who actually has control of that area. You see, it says, the use and regulation of common areas. The term common area is defined for all purposes, including loading areas. That's that back dock that we talked about all of today. We know from 6.3 the maintenance of those common areas, those aren't Chime Department Store's duties. Those are the landlord's duties. You can take that down, Mr. Beachy. Because Mr. White just came before you and he told you that Chimes was working off of convenience. And members of the jury, it's actually the plaintiff today who was suing someone because of convenience. You know, Miss Gilmore She's worked at Chime's department store for 10 years. Every day she's walked under that Chime's department store logo. Each and every day she's gone home and walked past that Chime's department store logo again. So of course, when she was hurt outside of Chime's department store, well, she sued Chime's. She certainly didn't walk under a sign that said Kermit Realty Group, members of the jury, and we don't blame her. The plaintiff didn't do anything wrong in that regard. She sued the wrong person. Members of the jury, but on January 23rd, the plaintiff simply made choices that Chimes just couldn't control. And now Mr. White got up here and told you that we were trying to blame Miss Gilmore. That in fact, Chimes was the one that told Miss Gilmore to go outside to that dumpster. Chimes was the one who told her to do everything that caused her injury. But I want you to think about the cross-examination of Miss Gilmore. What exactly she did that day? Well, we know that she walked down those stairs as usual. She held on to the wall, and that was fine. She took her smoke break, and as it was time for her to come upstairs, there was a door blocking her. Can we have a photo of that, Mr. Beachy? That looks something like this, ladies and gentlemen. And now we know that that door, it swings all the way open. But she chose not to open it. Instead, she chose to walk up inches of stairwell. That looks something like this. And when she chose to walk up those inches of stairwell, she became unsteady. She started to fall, and her friend reached out that arm to help her. She didn't take that person's arm. She didn't try to steady herself. Instead, you heard, members of the jury, that the plaintiff jumped. That she jumped herself off of that stairwell onto the ground, and that caused her injury. Members of the jury, those were choices Chimes simply couldn't control. Now, in a moment, the judge is going to instruct you on the law. He's going to give you some instructions, and I want to talk to you about those right now. Mr. Beachy, could we have the jury instructions, please? These are those instructions that you're going to get to see, members of the jury. You're going to get to assign responsibility to the parties. Now, as you can see, the question is, did the negligence, if any, of the named parties below proximately cause the occurrence or injury in question? The first is Chime's department store. We're going to ask you to answer that question, no. And I'll tell you why. It's because Chime's store simply wasn't in control of that area. Well, next, it'll ask you if Kermit Realty Group approximately caused that occurrence in question. We're going to ask you to mark yes for that question, and I'll tell you why. It's clear, ladies and gentlemen, that Kermit Realty Group was the one with the duty, the one who breached their duty of care, and the one that caused the injury to the plaintiff. Because it was Kermit Realty Group that should have maintained that back dock contractually. It was Kermit Realty Group that should have made sure that those steps you could walk up on. And it was Kermit Realty Group that should have made sure that there were lights available for the plaintiff. That final question. Jordan Gilmore. We're going to ask you to also answer that question, yes. Why? Well, think about all of the things that Miss Gilmore did. Well, she walked up that small portion of the stairs. She teetered off, even though she could have held on to the wall. Well, she left that door open that blocked her way, And ladies and gentlemen, she jumped. She jumped off the staircase herself. Well, then there's a second form. On that form, the judge is going to ask you to fill out percentages of responsibility. First, we're going to ask you to assign 0% to Chimes Department Store. We're going to ask you to find a Kermit Realty Group and Jordan Gilmore 50% liable. Ladies and gentlemen, this is the last time that I'm going to be able to come before you and talk to you today. Mr. White is going to have the opportunity to talk to you again, and there's a question that he needs to answer. If Chimes was really in charge of that backloading dock like he said, if Chimes really had control of that backloading dock, why did they have to ask permission from their landlord to remove those guardrails for that loading dock? Why did they have to ask permission, as was contractually obligated, to remove those guardrails? Make him answer that question, ladies and gentlemen. Hold him to his burden. We ask you find the defendant not liable. Thank you.
Why did Chimes have to ask permission? Why did they have to ask their landlord for permission to remove guardrails in the loading area behind their department store? The answer to this question is a very simple yet unfortunate one. You see, Chimes is only interested in pushing off the responsibility of their loading area when risk is involved. You see, they knew pulling off a guardrail in an area that was poorly lit, in an area that was desperately in need of repair, could subject their employees to risk of harm. And if they got someone else to do it, well, they could just point the blame. They could point their fingers at someone else. But when they want to make changes of convenience to their own area, they want to install massive dumpsters in their own area, well, they don't go to Chimes for permission, because that has to do with business. That has to do with their own bottom line. That has to do with their own efficiency. When Jordan Gilmore took a job at Chimes Department Store, she thought she'd be working for the Gellers. She thought she'd be working for a family business treated like family. Ms. Geller testified today that she cares about her employees' safety and that she's responsible for them. But her attorneys disagree. So you're left with a very complex challenge. Do you believe Ms. Geller when she says she wanted her employees to let her know of any potential safety issues? Or do you believe her attorneys who tell you that wasn't her responsibility? It's a conflict of conscience. But the evidence is clear. The facts have shown time and time again, Chimes was in control of their employees. Chimes controlled what happened in that loading area. And Chimes took initiative whenever they thought it would benefit them. And so today, they need to be held liable. They should be held liable. They must be held liable for the harm that they negligently caused to my client. So I'm asking you, find the defendant liable.
Thank you. All right, folks, let me judges, you need to send your score sheets up to Robert at this point in time, and nobody's to leave until we get I get a final okay, I guess I should say. Give me 1 second so I can send mine. Okay, those of you that are jurors, you can go ahead and turn your cameras on, and I'm gonna give each of you I think it's helpful to get some sort of constructive feedback because you've got multiple rounds coming. And I'm just going to ask each of the jurors, try to limit it to, one thing for each person so that they can, take what you say and move forward. And I'm just going to start on the top left of my screen with Tom, and then we'll go to others. So feel free to offer a constructive help for these two participants.
Okay, thank you. I appreciate it. Nick Beachy, can you put up the instruction that you put up during Joy's closing argument that related to control? And Josh, my comment is for you. This is not a very plaintiff-friendly case or very plaintiff-friendly set of facts. The stairs are only about 3 feet tall. And, there were about 3 or 4 different ways the accident could have been avoided by your plaintiff. And so I was really trying to take into account the admonition. Don't judge the advocate by the facts on the case. But the thing that I think will help you a whole lot is that instruction assigns responsibility either if the defendant has contractual control or exercises actual control. So what I think would make your plaintiff's presentation much cleaner from the get-go is to have your storyline narrow and specific from the get-go. She exercised actual control. Mrs. Whatever store your name is, if there were a hole in the front sidewalk and it endangered your customers, would you have the landlord fix it? Yes, I would. If it were a slippery drop of oil, bunch of oil on the front sidewalk, would you have the landlord fix it? I would. And the actual control here was exercise. So the theme might be actual control on your part, okay? And because I sensed that in your presentation, you were sort of struggling a little bit for this and that and the other to make your case, whereas in the instruction there, control can be proven either by contractual agreement expressly assigning the right of control or an actual exercise of control. So you know what your path is because this is a helpful instruction you're going to get from day one. You know what it's going to be. So if that's going to be your instruction from day one, you've got it locked. And so go ahead and use it, okay? That'd be my comment. And I think that if you do that, it'll help everything else flow a little bit better. Joy, I thought your cross-examination was really good. First of all, I thought both of you did a really, really good job. And I should have said that from the get-go. But we've been admonished to be quick and be constructive on specific things. And so I want to go in that direction. Joy, I like the fact that your cross-examination took little bitty steps, little nibble at a nibble at a nibble at a nibble, to which the witness is required to say yes. That's an extremely effective way to build momentum. There's just one thing that's missing on them, and I'm going to use this example to tell you what that is. When you're talking to the plaintiff about what it is that she could have done that would have avoided the incident, one way to do that on every single argument you should be making, there should be an internal impact. So for example, if you say, Miss Plaintiff, if you had just opened the door all the way, you could have walked right up the middle of the steps, right? And the next question needs to be what? And if you had, you would be safe today, wouldn't you? And then, you notice that handle on the door, you could have grabbed that handle as you were working your way around the door and anchored yourself to the door, couldn't you? Yes, and if you had, you'd be safe today. So impact, Yeah, I liked your step-by-step on cross-examination, but you can improve it by impacting those arguments with just one more question. Okay?
Thank
Thank
you.
you.
That's really helpful.
Yeah, good
Jen,
job.
Jen, I'm gonna go to you next. Looking at my screen. Go.
Trying to find my unmute. No, I wanted to commend you both for just extraordinary preparation. I think you guys get the problem with 24 hours, and to be as conversant as you were with the facts and to put things together as well as you did. You're to be commended for that, because in an age where people spend lots and lots of time on preparation, to be able to do as much as you did and feel really conversant with it, it's just great. It's great. So I'll start with Joy. Joy, one of the things I loved about your opening, it was very responsive, and all too often we aren't, as you know, sometimes defense lawyers can't be, but very responsive to the plaintiff. You had clearly listened to what he had to say and tailored what was very well prepared, but tailored it to how he was shaping his argument. And I thought that was really nice. I commend you for that, because that's hard to do in a competition or even later on in a trial setting. But when you do it, it serves you well. I would caution you to bring that same level of attention and listening to witnesses. Sometimes your witnesses get a little bit away from you. They're doing some things that you can bring back. You're smart and you're great on your feet. So use that same level of adjustment that you showed in your opening in your responding. You don't have to battle the witnesses, and that's always hard. And I'm going to say this, and the guys in the room can roll their eyes, I don't care. It's hard for women. It's really hard not to battle witnesses without sounding a little bit jerky. So you have to find your voice, and candidly, it's going to come over time. Just keep watching yourself. But as you watch yourself and listen, make sure you're listening, because if your witness is fighting you, and your plaintiff was, you have to figure out how to say, well, hold on. I hear what you're saying, but wait, because the whole trial, you created this aura of I'm the reasonable person. We are so in line on so many things. The divergence is very slight. I mean, you're painting yourself as that reasonable person. So don't let your witness get away from you. Bring that same level of responsiveness that you've got in your opening and your closing into how you're dealing with your plaintiff, and you're going to be great. I mean, you're already great. Now, Josh, I was a plaintiff's lawyer, and it's hard when you get this case. It's just so hard. You're like, whoo, what do I do with this? And you're to be commended, because you just hit the ground running and went after it, and you did a great job. Like, all I could think of was, if this were my firm, who was on intake that day when this case came in? One of the things I think you did well, and I don't want you to lose it, there's a fine line between injecting your personal voice and being prepared, and your voice is a great one. You have a very easy way about you, so keep that. This isn't going to be a comment that probably makes sense in this moment, but you have a great voice. Like, how you present what you present and who you are as a lawyer, it has a credibility level that will make jurors want to come along with you. So as you do things, whether on the defense side or the plaintiff side, as you're in the competition, don't lose that voice. Don't be so over prepared that you lose your voice, if that makes sense. Some people get married to a script. Some people get married to an opening statement. What you did, and did very well, was allow your personality to come through. And sometimes that's hard for young lawyers, but I just thought you did that very, very well. But it's a cautionary note, because as you get deeper into presentations or you do things in front of court, sometimes you just really want to stick to, I can't miss anything. But you have a great voice. Don't ever lose that in what you're doing, because you did both well today, and I hope you keep that up. So good job to both of you, and it was a pleasure to watch. Thank you.
Thank you.
Sarah, go ahead.
Thank you. And I'll actually pick up where Jen left off with Josh. I really enjoyed watching you present your case. And I think that had to do with your voice and your personality. Like, I just enjoyed how you describe things, your phrasing. And during your closing, I thought, this is a really good closing. Like, there's no way you'd ever win on the merits in my mind, but this is really good. and you made a really tough position seem very possible and tenable, and enjoyable to just listen. And I really, you're good on your feet. You were good on your cross. I wanted to mention it. You had, for me, just enough strength. You're, of course, looking at gender, you're cross-examining pretty adorable, nice women, right? Or the female that and so you gotta watch how you come out the chute, because no one likes a bully. But you balanced that really well with enough strength to do what you had to do. I would say the thing to work on would be motion and limine law. That was a little tricky there. But otherwise, I really enjoyed watching you try this. You got the tough side, and you made really good of it. Joy, I really enjoyed watching how you were able to weave evidence into your direct and into your cross. You've got to have a comfort level to do something other than, asking what you want to ask in your mind, to be able to move to a exhibit. Because once you get to an exhibit, you've got to kind of be off script a little bit, because you got to work things out, and you're waiting for someone to play it, or maybe you're playing it, or and I really liked your control of your courtroom. When you're the lawyer, you want to portray that you are in control of your courtroom, and I thought you did a really great job with your with how you handled the evidence. I thought that was great. And I will say, for your thing to work on, you'll learn once you have an actual real case and you have to read a transcript of your presentation. It's hard to read after the fact what you said, and that's where you start to notice little ticks where if you say ums or whatever. And yours is, when you're on cross, when you ask a question, almost every time you say, right? You did this thing, right? That's not true, right? You walked down the steps, right? And that noticed to me, and it was a little distracting. And that is super fixable. So when you talk, you should be thinking about how it reads in a transcript. And so maybe switch that up. You don't even have to say you walk down the stairs. You don't even have to say a right, or isn't that true, or yes, or what do you. So maybe just try to think about your mannerism of how you're doing that, just to kind of really polish up what is, by the way, a very polished presentation. So good job to both of you. Thank you, Judge.
Jason?
Yeah, I think you guys both did an outstanding job. I was very impressed, especially with the limited time that you have to put this together. Josh, I really enjoyed your closing argument. I was real impressed at the end there, how you just pulled it all together, and you made a very, very difficult case there in the closing sound like, hey, maybe you can get there. And so as a plaintiff's lawyer, this is a tough case. The one thing I would, I guess maybe tidbit of advice from my perspective is on the cross of the defendant. I think you could have probably done a little bit more, and I would have focused on the fact that they basically created this danger. They created this risk. When they moved in there, the railings were there, it complied with OSHA. The only reason that it doesn't comply with all those regulations is because they wanted to remove it. And I would have focused on that a little bit more with the defendant in the cross-examination. I think that statement, that prior incident report, I think you can work on some things about getting that in. That was likely a business record. It's in their normal course of business to investigate those kinds of things, to document what happened, what people said, to maintain those sorts of things. Good questions would have been, what did you do after that report? Tell me when it is that you picked up the phone and called Kermit and said, you know what, we really need to put those railings back in place. Can you tell me when it is that you sent an email to Kermit to request that those rails go back in place? So I think you could focus on what they didn't do after that prior incident. And I think that prior incident is also still very relevant here. I think in the motion in limine, again, you're kind of struggling there with how to get that in there. But hey, similarities between the two. Both incidences involved the darkness. there was no railing there, and there was issues with the edge of the concrete. So it's a very similar situation, and goes to the issue of notice. The one thing I'd also caution you that you went to using the word lie in your closing, and I think it's better, even when you think that the defendant has lied, let the jury come to that conclusion. Instead, say something like, but was that really true? Was she being really honest and genuine about that? Let's look at this. Let the jury come to the conclusion that that there was a lie involved instead of you using that term. Joy, fantastic job. You had a lot of control. You seemed very deliberate. Your objections and your motion in limine and legal arguments were right on spot. And I thought you did a great job with that. The one suggestion I give you is on cross-examination of the plaintiff. I would have kind of ticked through a little bit more that you knew it was dark, right? You knew that there was no railing. You knew that the edge of the concrete was a little old, a little crumbly. Go through that, and then go through that. You say you went up and down these stairs roughly 20 times a week. Is that right? And you work what, 50 weeks a year? So that's 1,000 times a year that you would go up and down there, and you did that for 10 years. So that's 10,000 times at least, give or take, that you've been up and down those stairs, right? Yes. And never once have you ever had a problem where you fell down those stairs? No. Never once have you thought that it was so dangerous that you went and told your employer that you were concerned about it. So there's a little bit more I thought you could have done with the plaintiff on cross-examination. You have a strong case there, and I think you could have done a bit more with it, but you did a great job. The one other thing you might just throw out too is that the smoke break. Nobody made you take a smoke break. I think some jurors are going to kind of be would go. Yeah, it doesn't have a really legal effect here, but I think some people are going to think, hey, you're going to go take a smoke break. You know, you're kind of doing this on your own time, and that's a bit on you. They might have a little bias towards that. That's all I got. Great job, guys.
Thank you for those comments. Look, guys, I've been doing this, I think, since the very beginning of Top Gun, and I will tell you that this is the closest round I've ever judged, and by some considerable sum. I really struggled with each and every one of the things that we're to pick a winner on, and it was very difficult because both of you have extreme talent, and I only wish that I came close to the level of talent that y'all had at the end of my 37-year career trying cases across the United States of America on the defense side. I am a defense lawyer, but I am a closet plaintiff's lawyer. I have always been a closet plaintiff's lawyer, and in fact, in my retirement working here at the law school, I'm going to someday try a plaintiff's case very successfully for lots and lots of money. So I'm going to address the plaintiffs first, and then I'll come to what I did for 37 years, which is the defense side of the docket. First and foremost, I've got to tell you, I was light on you for the motion in limine violation compared to what a federal judge would do to you if you did what you did in this courtroom. Okay, state judges, I tried to act like a state judge more than a federal judge, and so therefore I gave you great leeway in that violation. But you've given her a pretty substantial point of error by raising it without addressing it with the judge from the very beginning. Part of the reason that I made that ruling is I wanted us to have the ability to see how y'all deal with a ruling like that on a motion in limine. Don't go down that path. It can end poorly, even if you have the pristine case of all cases. You understand? Address it with the court. Your Honor, I have a matter that we need to discuss outside the presence of the jury before you go down that. You got that? Remember that always. Second, I'm going to echo on a couple of things that I've already said and give you an idea here. If you're on the plaintiff side of the case and the facts as I thought they were presented were more had a tendency to be on the defense side of the docket. But I think there's one crucial fact that's been touched upon that you should address from the plaintiff's perspective. And that's that Tom talked about, that definition of control. is one that I think you can play on. And then Jason picked up on it some. I would use that from the very beginning as the plaintiff. It was your choice to remove these railings. You made a purposeful choice, and your choice only, to remove the railings. Well, why are railings there? Railings are there to protect people. That's why you have stair railings. That's why you have railings on ladders. That's why you have railings to begin with, is to prevent people from, unfortunately, falling off. That's why railings exist. It's your choice to do so. And then for 9 years, every month of those 9 years, every day of those 9 years, every single year, you made the decision not to call and have those railings put back. That was your purposeful decision. And I think that gives the defendant here control in the minds of the jury, given the definition that's there. And I would make the case about it. And then you could throw in the garbage can as additional evidence. So my first argument about control is the purposeful choice. And if you echo that with, what are the railings there for? They're there for protection. So you made a purposeful choice to remove the protection for your employees. Guess what? Now you've got negligence, because that's a purposeful choice of taking something away that's there for somebody to be held liable. I mean, to protect the people. Got that? So I would have focused on that. And I think if I'm trying it, I know y'all got to switch sides and all that kind of thing. Keep that in mind. I think that's the most crucial fact from the plaintiffs, that you've now heard three of us specifically talk about. Okay, you got that? Fair enough. I thought your presentation, both of your presentation was masterful, and your ability to flow through the facts was just beyond anything that I've ever contemplated having the ability to do. So I really do appreciate that. Joy, I thought that your ability, as has already been said, to weave in the facts in your cross-examination and in your direct examination was pristine. I thought it was very well done. I thought it was very well organized, and I thought it was very well thought through in terms of the presentation. Having said that, in light of what I've just told Josh, if I'm trying this case from the defense perspective again, I've got to deal with that issue of the fact that my lady took those guardrails off. I think that's a crucial fact, and you've got to have the explanation more. I thought it fell into sort of the convenience. It was convenient for us because I didn't want to have the people that are unloading stuff, put it into have trouble getting stuff into the place where we work. So you're going to have to think about, how can I address this issue from the defense perspective? The fact that she's the one that removed the railings. You get where I'm coming from? I think you got to think about that. Okay. I also think the one thing that was confusing to me is I don't think there was any other stairs down from any of the other stores that were there. This was the only sort of stairs that went up and out. And so, I mean, in some respects, that's a control issue. I didn't see anything. Maybe there was. Was there
Yeah,
any?
Each business has a sets of
Good.
stairs.
Okay, that needs to be made clear, because I was thinking about that the entire time as I was going through. And I will say this, and I'm speaking about this, and I think Jim mentioned it. I think it's the tone that you have coming out with the first witness that you have. You've got to be careful with that tone. And I don't care whether you're on the plaintiff or defense side of the docket, but particularly when you're on the defense and it is the plaintiff, you've got to be careful with the tone of the questions that you ask. Particularly, I think and I don't mean this derogatory. I mean, it's particularly difficult for females. I just think it is. So I just would be careful with the tone coming out. You can start with the same methodical point by point stuff that you went through with the witness, and do it with just a little bit of a less of a more an aggressive tone. if that makes sense. I'm hoping I'm being specific. I think you can do the same thing. And then as the jury gets to know you, the tone can change. I've always found that to be true from the defense perspective. When I was very, I was very methodical to start off, but my tone didn't get more aggressive, I guess, until I got the expert on. I had one question for you. Why didn't you call the other witness? I don't remember what they say. You had an opportunity to call somebody else?
Yeah, there was a defense expert, but it didn't really align with our theory.
Oh, I see. Okay. All right. Hey guys, y'all did great. And I can't tell you how proud I am that just to know that the future of people who are going to be trying our lawsuits are going to be people like y'all with the talent, skill that you possess. You should each be very, very proud of everything you've accomplished. And it was a pleasure for me to sit as the presiding judge for two extremely talented people. Thank you, and good luck through the rest of the competition.
Thank you so much.
Thank you all so much for judging.
Oh, we're done, by the way. I should say that we've already done everything. So I've got the go ahead. You can log off and get ready for the next round, folks.
All right, thanks.
Yeah, I'm having to be on my phone because I can't get my old computer, which I brought to Waco, to work. Hold on.
Able to for the time being.
There. I've got it on my phone. I took my robe off for the interview. I told Jim just a few minutes ago that it's the first time in my life I felt like I was in a position of real power.
Ooh, very nice. Very nice. How's her resident power broker, Miriam?
No, I'm judging today, and it's really a great position to be in. Just have all that power. Nice to see you, Mary.
Yeah, nice to see you. Good morning. I thought I wish all of you while you guys are all on.
You're mute.
And just to give you some insight into the program, we actually teach a lot about technology in the element. That sounds great. I'll share that.
Out of curiosity, what time is it there, Mary?
It is 11 p.m. currently.
Okay.
Oh my goodness.
For bearing with us at such a late hour for you.
Oh no, pleasure's all mine. Thank you for making the time to interview me today.
Well, we're looking forward to it. I enjoyed my conversation with you, whatever that was, about 3 weeks ago.
Yes, that was great. That's right. Thank you so much for getting on phone with me for that. Well, Mary, one of the things that I think is true of this program is we keep it fairly intentionally small because we feel like part of the value is that kind of interaction that the candidates can reach out and, you know, be in contact with us, with the professors who are teaching the course, and you don't feel like you have to go through a very formal process. One of our candidates in the current cohort is in London, and we've been emailing back and forth about his final projects. Just he was, you know, because with the time difference there, he can't always join our synchronous sessions. We try to offset them, but the ones that are at 7:30 at night, it would be, you know, 3:30 in the morning there, or 2:30 in the morning there. So I'm like, no, you don't need to be on those. You can watch them. Yeah, no, that's great. I think that was one of the things I was, you know, reading up about the program, and I thought that was very interesting. And I kind of like the fact that it's a smaller cohort, because that way you can interact more with the professors, and you know, if there are questions, it's easy to ask and access, which I think is perfect. We had hoped that the candidates and faculty would form close connections, but you never know when a large part of it is asynchronous, and we've been very, very pleased with what a tight-knit community this has been. I think it's been a real a benefit of the program that exceeded expectations. That sounds wonderful. And yeah, no, I was looking forward to like talking to you guys. I did have one question. I'm sorry for bringing this up earlier on in the interview. But it was one of the courses you offered during the second trimester. It goes by the name of the Management of Electronic Discovery. And I just found that very interesting. So I thought if you maybe could just let me know a little bit about it. I was just very intrigued by it. So I thought that would be something interesting to talk about maybe.
You want me to jump in on that?
Go ahead.
One of the, of course, one of the very dominant aspects of American style, US style litigation is a heavy emphasis on discovery. In so many jurisdictions outside of the United States, there is little to no discovery. And because we have very wide ranging allowance of discovery within the US, the vast majority of that today is in electronic form, which introduces a variety of both new legal challenges and new technology challenges. And oftentimes in US litigation, a very large piece of the cost of litigation that has to be managed is the management of electronic discovery. So that course is focused on what are the defenses to electronic discovery, how much has to be allowed, how do you manage the cost of that. So it is an introduction to not only the law, certainly that, and the procedure, but also the technology. So that and we make it clear, we're not necessarily teaching people how to do all of that yourself, but certainly as one managing litigation, you have to have an understanding of the limits of it and the extent of it in order to put reasonable expectations on your litigation team. So that's what that is.
Our professor who teaches it is a really intriguing person to be covering the topic because he both is in private practice in a very major firm. He's an international practice as well, but he's involved with a group called the Sedona Conference, which in the US has been instrumental in promoting best practices in e-discovery. So he comes at it from a variety of perspectives. And I think does a good job during the on-campus session. He actually has the candidates work through what would be an e-discovery, meet, confer, negotiate, so that you get a sense of what it would feel like to be involved in, as with many things in the program. It's very practical, very, we really want you not to understand it just theoretically, but to have some hands-on experience.
And Mary, that raises a point. And you and I had started talking about it at least briefly when we were visiting by telephone earlier. And that is one of the things we're always seeking is to be sure that this is a good fit for our candidates because of what Liz Fraser was just talking about in terms of that network and bonding. We want to be sure that people have the shared experience that's fitting their needs. This entire program is not completely dedicated to U.S. style litigation, but predominantly so. That's certainly the major thrust of it. And so one of my real questions is, does that fit, or how does that fit your needs? We want to be sure that we are addressing your needs.
That's a great question. And after our last time, Professor, and I did go over the curriculum once more, just to kind of, brief myself on it and see what the main points were. And I think it would be such a great fit because eventually I do plan on practicing in Pakistan. And I think kind of having an overall perspective that's well-rounded in terms of, litigation management, I think that's key and that's really what I'm looking for. And, I think the course that you guys have to offer at this LLM program, it fits my needs. I think that's exactly what I'm looking for to be able to apply it when I do eventually start practicing over here. So I think it's a great fit for me. And I go over it once again to see if, and it was, I feel like it's a perfect match. So yeah, to answer your question, I do think that this would be a great fit for me.
we're certainly very cognizant of the necessity of looking for that kind of fit, because as Liz was mentioning, we have some international candidates right now. We've had them from Canada. I think we've got one coming in from Brazil. We've got President from a couple from UK, as well as from Uganda. But given that they may not be involved in U.S. style litigation, we're always hopeful that you're drawing from the program what really will fit your needs, given that your litigation is not necessarily like and not U.S. based style litigation. Having said that, I will say that there are many of the business concepts that that apply across the board. Much of what Kyle teaches is recognizing what is your legal environment, what are the cost factors involved, and how do you anticipate those managed. So that has broader application.
Well, and the cybersecurity and privacy courses, the data analytics, I think, have global application as well. The whole management of data throughout the litigation process, I think, gets addressed. The other thing that's a benefit for us, Maren, is we do like to get feedback from our global candidates about how they're applying the courses, because we tweak the curriculum almost constantly. We think it's such an innovative and changing field that it's very important for us to keep current. And so that does inform some of the aspects of what we teach. So there's a benefit to us from having global candidates as well.
Absolutely, yeah. And I think, like you said, a lot of the courses are very applicable worldwide. Like I think in any part of the world, there's a degree which will be applied to, whatever aspect of our practice or wherever. So I think, that's so important to keep in mind when looking at a course like this, because it has so much more to offer than what it just seems to be giving on surface.
I know you had a question about e-discovery. What other questions do you have about the program? Because we like to be sure that we're answering things that maybe aren't just apparent from the website or the other materials you've had.
I guess just something to keep in mind. Right now, typically, how many candidates do you take on for the LLS program? Just like an estimate, maybe?
In any given cohort, it's going to be something, give or take 20 candidates, sometimes a little below that number, sometimes a little beyond that number. But it's in that sort of range. Again, because it facilitates the way in which our candidates get to know each other and work with each other.
The other thing we've been trying to do, because we have different cohorts going at any time, we just had a January group start. We had been a once-a-year start, and we just added a second one to address demand and scheduling. And so the other thing we're trying to do, our June on-campus session is next week. We've set up some joint sessions so that they can also meet each other. You're on sessions often with the people in your cohort, but it's nice to have access to others. And then we also very intentionally connect people. One of the women in our third cohort is running the legal department for a healthcare system that's across several states. And a graduate in cohort 2 does much the same thing for a large healthcare system in Texas. And so we said, you two ought to talk about where the synergies are, what you've learned, how it's applied. So there's also that benefit. With your training back in the UK, you might want to meet the two Brits we've got right now to talk about what they're doing with it globally. So we do try to not only connect you horizontally, but also vertically.
That sounds great. That was one of my key questions, I guess, just to see how the class goes to get around idea.
One of the things we also routinely required about it is the time management aspects of this. This program is designed for working professionals, but still takes time. You're typically going to find that on average, and it's much of this is self-paced, at least until you get to the intensive weeks on campus. But two questions here. One, on average, it's taking somewhere in the 12 to 15 hour per week range. Do you have time to allocate to that? And then secondly, in terms of traveling to campus for these intensive weeks, there is a remote option, but there's so much more valuable in person. Is that something that works with your travel abilities, your time schedule? Have you looked at all of that?
Well, so firstly, the time management question. I think after completing my graduate diploma in law in London, I think that's really taught me how to manage time well and efficiently. It was a very intensive course, and there was a lot of learning involved since it was all online because of COVID. I think that kind of forced me more to be more careful about how I manage my time. So I definitely think, I think the time management aspect, I should be able to handle. I'm very confident myself to be able to do that. And in terms of being on campus and being present, I fully agree with you. I think being present in person, it makes such a big difference in the learning process. And I definitely, I think, given an opportunity, I would definitely take that on. The only issue is that since I am a Pakistani citizen, I would require an I-20 in order to travel to the US on a student visa, essentially. So if Baylor is able to offer me that, that would be wonderful. And if not, then I guess I will do the course remotely and whatever works better. I think that should be fine.
And I'm thinking that Catherine, you don't address the I-20 question.
Great.
And have you, Graham, I'm trying to recall, did you actually have direct conversation yet with Catherine Sims?
Not yet. All we have spoken about is the fact that there would be an interview, and she said we touch base, I think, afterwards, and she let me know what's going to be happening. So I thought once, if I get to that point, I would then talk to her about, the steps ahead, and then we can try that.
Yeah, we can get that visa issue addressed and answered. So good. Obviously, anything that we can do to assist with that, we stand ready.
Okay. Thank you so much.
What other questions do you have for us?
I think there was that one course that really intrigued me, which I'm glad I got an explanation for that. That sounds wonderful. But that was about it. I think nothing else comes to mind as of now. If it does, I would definitely shoot you an email or let you know, and then we can touch base. But I guess now you've answered all my questions.
Ma'am, I have a question for you that I hope is a softball. It's not intended to put you on the spot, but one of the parts of the course is a research project looking at how you would apply litigation management principles or really developing any aspect of litigation management through research. Any thoughts, given your plan to practice in Pakistan, what might be an interesting research topic for you? And I completely understand if it's too early to know that, but I thought I would ask because sometimes candidates come in saying, there's something I would really like to do, and others are like, not yet. I want to develop some thoughts around it once I've enrolled in the course.
That is a really good question. I think, considering the fact that I would want to eventually practice in this part of the world, I think something involved with corporate law in Pakistan, I think that would be interesting to kind of see litigation management being applied there. So I think being able to, control and plan and organize, know how to implement legal services in the context of, whatever the given situation is, I think that would be a really good thing to kind of apply in the corporate side, the corporate law part of Pakistan. Because I think that's kind of what I would like to focus on, if given the opportunity.
I think that would be great, and your coursework would directly inform that. That's a huge issue, I think, in all the corporate offices. How do we control legal spend? How do we plan and apply business principles and practices? So I think you get a lot of good information. Cool topic. That's great. Yeah, and I also think that since we are a third world country, there is definitely much more room for improvement. So I think being able to learn and bring that back here and put it into practice, see ways in which we could change the legal process and the way things are done here, I think that would be so much more efficient and helpful for the legal side of this one.
Miriam, what is the mechanism for people in Pakistan to resolve disputes among citizens? I mean, what is the litigation practice there where there's disputes? What do people do?
It's usually just, you file a case, you find a good lawyer, you go to a firm if need be, and then they carry out the process for you. I'm joined with a firm over here that goes by the name of Headley Moja. It's one of the decently bigger law firms in Pakistan. And I think that's kind of what the process is. Just you work through a lawyer, they sort out all your paperwork, and that's how you get it close to the process of litigation. Well, I think it'll be exciting for us to learn more about the system there as well.
Yes.
Good. Well, I know good time to bring something to you guys.
That is, by the way, we make very clear, we are in a constant learning mode. And so we enjoy that aspect as we are learning about different aspects of practice and different systems of practice.
Very much so.
Baron, we've really enjoyed
Enjoy
this
meeting you.
time with you. We're so glad for your interest. Next steps, typically, we meet and make decisions very quickly so that we can get information to you. You can have the resources you need to figure out how it will work. I'm excited every time we get a really interesting global candidate like you to apply to the program, because it just brings such richness to our cohort. Thank you so much, and I think I would be the last one in this situation if I'm able to talk by wonderful professors like yourselves, and I really do appreciate even you guys giving me this opportunity to take an interview today. So thank you for that.
Thank you.
Very much enjoyed it, and I'm looking forward to the next conversation.
Thanks, Miriam.
Thank you so much.
Enjoyed it. Thank you.
Bye.
Yeah.
Thanks. Bye.
Hey, man. Sorry, I was on an interview. How are you? I just finished. I got my next round going to start in another 30 minutes. And I have 2 interviews that I have to do. That's what's going on. So, how are you? What? Okay. All right. Anything happened this morning? She has 2 more interviews. Oh, well, that's good. All right. Are these? Yeah. Yeah. Really? Okay. Well, that's good. So now she's got 3 interviews? Well, that's good. That's good. That's an answer. Very about it. Everything else. Yeah. Good. All right. Well, what time is his practice tonight? I mean, Don wants to get worn out of baseball. I'm too early to rest. I think I'll be home. These things take a couple hours, 2 hours, 15 minutes, something like that. I guess I'm taking. Anything else happen with your legislation? Okay. All right, I guess I'll just check back with you in a little bit. I gotta get on the phone call here, so. All right. All right. That's all good. Have fun.
Hey, Tom.
How are you?
Rebecca just said that she was having a joint on the road, and so waiting for her. If you guys can put on there for something up here. Rebecca, are you there?
I'm here and Jim is here.
Okay, Rebecca, are you on this call? Or is it just Jim and Kyle?
Jim's here.
And Kyle's here.
Because Liz is on another call somehow. Another meeting. I'm gonna try to send a whole new meeting. I don't know why there's two different meetings going on.
Okay, we'll look for it.
Okay.
I guess we hang up.
Here comes Jim. Yeah, the camera ready on Rebecca. Okay. At least most of us are in one second. I'm sorry, guys. I really am not sure what happened. Jim, what room are you in?
Just at the law school.
I'm sorry, I was looking at Kyle and said Jim. I meant Kyle.
I'm in one of the, let's see, courtroom 7, which is actually in a classroom on the second floor.
Well, I didn't see the windows and the configuration, but couldn't tell which one it was, so.
It's 2 something, so. They put me in a non-courtroom. I'm in a classroom.
Did they set up the bench? And, we have courtroom setups for some of this. Did they set it up or just?
No, they just gave me a table with an Apple computer and a chair and a robe. I got a robe. So.
That looks very judicial.
I'm trying to.
The glasses help. I'm a little bit sad because my eye doctor has got my vision corrected where I almost never need my readers anymore. And I miss them as the stern prop.
I use them.
I kicked a kid out of class yesterday, and boy, you could see the ripples through the whole group. I'm like, I need to remember what an effective tool this is.
I thought you could get in trouble. You can get in trouble for doing that now, but can't you? I mean, it can't be that way. You're challenging your inner Muldrow. That's what I was told. Yeah.
No, I don't think anybody has to wave us to send us that memo, honestly.
You got to check.
Emma, so 2 weeks ago, we had a cell phone go off in class that I demoed. Last week, we had it go off, and I said, okay, I'm done with the cell phones. In Dallas County, it's like a $500 fine. They confiscate your phone. This is a professionalism issue. I am done. And his phone went off yesterday. I was like, get out. He's like, yeah, there wasn't even, but you looked around and every face was like, holy cow, that really is a thing. And then I stood it up for 2 hours in the afternoon. I thought, I don't want to give you a memo. I want you to learn the lesson. So here we go.
Yep, there you go.
It is just very distracting to the processor. It's a pretty complicated charge stuff. And I'm like, no, just no. So
Yeah, and there's just not an attention or respect for detail.
no, there's not. So, and to his credit, he took it in the spirit in which it was intended. Get your gear together, son.
I remember when before you banned computers, I'll never forget that summer that I taught up here, first day of class. Powell was in there. I remember those kids, they pulled out their computers, and as soon as I started talking, all I was getting was click, 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 on the computers. And I stopped in the middle of it. I said, everybody, take those computers, fold that lid down, pull out a piece of paper, a pencil, or a pen. And I said, you're going to take notes of what I say. I cannot stand hearing that clicking noise. And I remember they turned to Powell and they said, is he serious? And Powell said, do what he says. He's teaching the class. It drives me nuts because all they're doing is it's like a recorder. They're not paying attention. And part of the learning process is that, part of the learning process is being able to translate what's being said and and writing it out so that you can comprehend it, as opposed to it just drove me nuts.
Hello, I'm sorry for being so late to your meeting. It looks like we had a problem getting the email released.
Not a problem.
No, yeah.
Is that Rebecca?
Sorry.
Yeah.
No problem. I got an email from Whitney confirming the meeting today, and I got her call, and we can work with Joseph, and I guess it's all work.
Good. We're glad to have sorry for the confusion.
Yeah, and we're all trial lawyers, Rebecca, so we're used to plan A didn't work, so we go to plan B. You gotta be flexible in this world. Right, WebEx, Teams, and conference lines, and anything you can get to work.
That's right. Very true.
Well, we are very excited to be talking to you. I know we've got your personal statement, but I always like to hear in your own words, what draws you to our LLM, and what do you hope it will do for you professionally? Well, that's an easy question to answer, fortunately. I was drawn to the LLM because it is a litigation management degree. And my specialty has been litigation for the past 3 years. But it would be extremely helpful to be trained in managing teams that are litigating. I ended up with a team of about 28 attorneys and no project management experience other than just family experience managing a horde of small children. So while that's helpful, it's not as helpful as learning how to manage complex litigation. And especially well set and tapered to deliver that. Yeah.
Rebecca, I'm very interested in Law HQ. I certainly, I looked it up. I have some sense of what your firm is doing, but I'm very interested in the genesis of that firm and then how you came to take on the position that you've been successfully taking on.
Well, that's a funny question to answer. One that I love to talk about. As co-founder of the firm, that's how I ended up in the chief legal officer position, but it was a title with many hats. Clearly, when you're starting out in your own firm, you end up doing the accounting and the hiring, the HR, and the website. I have to just name the website. I had different ideas for it. It's helpful if you were hoping to look at our website, but we have been extremely focused on litigation. So to shorten the story up a bit, my friend Thomas wanted to do something about all the spam calls he was getting on his phone. And he was extremely irritated. He's an attorney, but he hasn't been practicing as much. He's gone into business, and he has started a company that's funded today, which is a Kickstarter company that helps people market their Kickstarter ideas, and has done very well, but he's just annoyed with all the spam. So what he wanted to do was find a way to stop it, realize that the Telephone Consumer Protection Act penalized spam, and that the problem was finding and identifying the spammer, mostly because it's very tricky to track that kind of technology. It's tricky to track a phone call. But we have technology now, it's been 20 years, and we can follow them. It used to be that they can put their numbers and go and whatever, know who they are. With the sophisticated things that we developed, we can track them. So it's a huge possibility, it's lucrative. If you can prove who's doing it and you know they have assets, you can go after them and win even by default or on judgment. So that's what we did. And one of our main accolades or one of our main accomplishments in the last 18 months was that we needed to function as a national firm. But in order to do that, we needed to be able to operate in all sorts of states under our trade. And there were still 9 states that had antiquated rules barring law firms from practicing their trade. So I'm very happy to report that just a few days ago, Texas became the last state in the nation to allow trade for law firms that use the 9 lawsuits we filed.
Yes, I saw Texas was one of the 9 states, and I was thinking that is great that you're going after that. Because I do think that has been an antiquated rule.
Well, it's still operational for any law firms practicing partnership, which is a form of branding in and itself. You know, if the partner dies or retires, the law firms are still allowed to use the name. And it's because it's a brand. But that's still not a problem. You can still do that. It's just that Texas law firms have been practicing they just haven't been allowed. So hopefully that. Yeah, I know of a firm in the Dallas area where who got to use the prominent dead partner's name became a heated battle, and there was much maneuvering
Big time.
and courting a widow. I mean, it was a little unseemly when you think about it, but to your point, Rebecca, I love, first of all, how much Thomas's description of being a serial entrepreneur, but I love the synergy between what you're doing and what we're doing, and how much I think our program really could be immediately effective for what you're doing, streamlining processes, automating processes. I'm thinking about our early case assessment courses where you really jump on these up front and use business strategies and project management to plan out how you're going to proceed. I think there could be some really dramatic wins for everybody, Mary Law HQ and our executive LLM.
Absolutely.
I agree.
One of the things that we always ask or always want to explore is the fit, because we are looking for the right fit. As you may have seen, unlike a lot of LLM programs that are open to people coming straight out of the JD experience, many of those LLM programs are really setting people up for academia. And we don't take that lightly, but honestly, the reason we have a practice requirement is because we are looking for people that are going to be applying these matters in a very practical way. And that is my sense with you. But let me just ask, is that what you're looking for? That is very practical application, as opposed to looking for an LLM program that sets you up for academia.
If I wanted to do academia, I would have gone straight over to a clerkship and kept going that route. Everything's been practical for me. Even in law school, I was working through my lessons, and I'm just a very kinesthetic learner. So as I would learn about civil procedure, I was looking for practical examples of what I was studying and drafting my own, which set us up to succeed. Well, I was a first-year graduate when I started law HQ. And now that it's been 3 years, we've had a lot of experience in federal court, multi-district litigation with the JPML, and it's become a glaring need to me. I've always wanted to get more education, more skills, so that I can be more prepared for what we need. But clearly, in my role, I need to be able to manage the teams in the litigation from the start. I needed to hit the ground running, and I think I've run out of runway. I've done as much as I can with my guesswork. And what we really like and appreciate some training so that we can grow and expand. What we're looking at is hiring hundreds of attorneys across the nation, and I just can't manage that with my limited experience. I know enough to know what I don't know, and what I don't know, I ask questions to get help. So the short answer is yes, absolutely.
That's interesting. You got, Rebecca, your involvement with the JPML, MDL process, and all that kind of stuff. You need to understand that part of the makeup of our faculty include people that are essential in that arena. And when I say essential, I'm talking about people that are considered essential on both the plaintiff side and the defense side in terms of managing that kind of litigation. So you're going to get to learn from some of the very best of the best in the fields that you're operating in, without any shadow of a doubt.
No. And let me just say, I'll give you a short response to your short answer. And you sound like exactly the kind of person we are looking for, from seeking out the experience, seeking out the practicalities, and being highly motivated.
That's true.
I like your answer.
Rebecca, what's really funny to me is we use that phrase and hear that phrase all the time in the program. I didn't know what I didn't know. And so I think that really resonates with all of us because, yeah, That's where we are with litigation management.
Well, too many of us don't know when we hit that wall and it becomes glaringly obvious to everyone around you. So I always want to be aware of my limitation and go find out what else I need to learn.
You know, in this challenging and aggressive growth stage, Rebecca, typically it takes 10 to 15 hours a week to do the coursework. We build in breaks, we build in catch-up time because everybody in our program is busy and actively practicing. Is that feasible for you, given all that you've got on? And the answer may well be, whether it is or not, I desperately need these skills, so I'll make the time. But what are your thoughts about the time commitments?
Yeah, you make it work, right? So I'm fortunate enough that we are extremely efficient with LiveQ, and I've been able to streamline my time. But yes, like I have to make this work. The only problem for me is not going to be time, but money. Our firm is stretched as thin as we can get without bringing on new investors, partners. And that's not an option for a little while longer. So looking at the cost and watching the switching, I was like, no, I don't know if I can swing this. I may be personally paying for it for a little while. And I'll tell you right now, my salary is $105,000 a year, which is extremely low for the kind of workout that I've been putting out. But with potential for long-term equity as it grows, and it's liquid. So it's an investment up front, but it's something that I have to strive to do. So time, I would make that work. I went to law school pregnant. I was a caretaker for my mother. She had terminal cancer. And again, like 95-year-old grandmother. We have some serious time constraints, and I need to work. This is not something that is new to me. It'd be a pleasure.
Good. Well, and we can connect you with Catherine Sims, who is both our admissions and financial aid coordinator. We do have scholarship available. We do try to help you make it work. She's got some good information on, tax deductibility of some of it. So she's very good at connecting you with the resources and trying to help you plan out, okay, can I make this work? Because I think you're a wonderful candidate. I know we would love to give you some scholarship help and hopefully get you to the point where it becomes financially doable.
Right. And besides that, and given the fact that you're from Utah and I have an affinity for Utah, I have a place in Park City, Utah. And yeah, well, I'm a Utah fan because it's just so beautiful, just so good.
Yeah, I have to say, another reason why I've been looking at Baylor, and it might be a little biased, but I lived in Texas for 6 years, and I would claim it. If they would let me be a Texan, I would say it.
There you go. There you go.
Wonderful, wonderful. What else can we tell you about the program? Questions we can answer for you?
Oh, this would be your favorite question ever, but I'm going to ask it because a lot of people have made these comments to me. I'm skeptical of what I've heard from the colleagues, but they say that they generally frown on LLMs. It seems like you don't know what you're doing, therefore you went back to school. I'm sure you've heard this before, but what's your response to why an LLM is actually beneficial at any stage of my career?
I don't think that is, in a number of cases, I don't think that is necessarily an unfair description or question. Now, let me explain that just a bit. With the exception of a couple of very practice-oriented LLMs, traditionally LLMs have been focused on, as I already mentioned, a lot of people coming straight out of law school, straight out of the JD, looking to enhance a credential for beefing up a route into teaching. And we're not necessarily teaching highly practical skills. There's some exceptions to that, traditionally, like a LLM in tax or an LLM in healthcare. But they've often been used used as a route to just beef up credentials. So I don't think that's necessarily an unfair criticism or unfair question. However, that is exactly why I was asking the question that I was asking. What's your motivation here? Because this and then there are now some other LLMs in different areas that have the same approach that we have, and that is we are all about very much practical application. Or we
Hi, Judge. Can you hear us okay?
Hey, y'all, the judge isn't here yet. I don't think they get in until like 2:30 or something.
Yeah, that's okay.
But y'all are good.
All right. Thank
Did you
you.
have a question or anything?
Just checking the sound.
Yeah, sounds good. Hello, hello. Can everyone hear me?
Hello, yes, we can.
Great. Well, hi, everyone. Good afternoon. It looks like we have everyone with us on the Zoom call. I just want, Ms. Holden, are you using two different devices to participate today?
Yes, Your Honor.
Okay, that's totally fine. I just wanted to make sure, since I see your name up there twice, that that wasn't something, not that anything weird would be happening with that, but okay. Sorry, I'm making sure our third judge is ready to go. Megan, can you hear us?
Yes.
We're good.
Yep.
Okay, perfect. I just wanted to make sure you were ready for us to begin.
I'm ready. Thanks.
Perfect. Okay. Okay, if everyone other than our two counsel can go ahead and turn your cameras off, we'll get ready to proceed. Okay, the court is now calling cause number TGCB 001-21, Jordan Gilmore versus Chimes Department Stores Incorporated. Parties, can you introduce yourself, please?
Yes, Your Honor. Good afternoon. My name is Joy Holden. I'm joined along with my co-chair, Mr. Nick Beachy. We represent the plaintiff in today's action, Jordan Gilmore.
Good afternoon, Your Honor. My name is Paulina Piasecki, and I, along with my co-counsel, Natalie Bayer, we represent the defendant in today's case, Chimes Department Store.
Good afternoon, Your Honor.
Are there any housekeeping matters we need to address?
Yes, Your Honor. We've met and conferred before today's case, and we have a few stipulations that we've reached.
Okay.
Exhibits 2, 4, 6, 19, and 33. We'd ask that those be pre-admitted per stipulation.
Sorry, can you repeat the list after 19?
Sure, Your Honor. 33.
Okay, it's just one more. Perfect. Okay, anything else?
Your Honor, we would ask permission to screen share for outside of the presence of the jury for identification and foundation purposes, as this is a Zoom trial.
Yes.
Finally, Your Honor, we believe that defense has one substantive motion, but the plaintiff, we have no motions today.
Okay, any housekeeping matters for the defense before we get into those motions?
Yes, Your Honor. Just one housekeeping matter. As Your Honor knows, this is a negligence action, and the court has provided the parties with 4 sets of jury instructions that differed based on our intended theory of the case. And after consulting with our client, we have decided that jury charge number 1 would be the appropriate charge for the jury to hear today, and to have that shared with the plaintiff before the trial started. We've already shared that with them today.
Perfect.
But with that, we're ready to proceed to motions, Your Honor.
Go ahead.
Your Honor, the defense moves to exclude evidence of a safety measure our client, Chimes Department Store, took after the plaintiff's accident in this case to improve subsequent remedial measures evidence under Rule 407. So by way of background, this is a negligence action in which the plaintiff has alleged that it was the fault of Chimes Department Store when she fell from the stairs that were connected to a loading dock behind the store during her shift one evening. Now, one issue in this case is whether there was adequate lighting out on that loading dock. And there was a light above the loading dock at the time of the fall. However, Chimes did not have a light switch to turn it on. And after the plaintiff's accident, Chimes installed a light switch so that its employees could turn on that light. Should the plaintiff attempt to offer this evidence, it would be solely relevant for the purpose of the plaintiff trying to prove negligence or culpable conduct on the part of the Chimes store. And that's expressly forbidden by Rule 407, and we'd ask to exclude any reference to those actions.
Response?
Your Honor, we won't be offering that evidence for subsequent remedial measures under Rule 407. We will be offering that evidence to show both feasibility and control. By way of background, my client, Mr. Gilmore, was harmed when he fell off the stairs in a dark alleyway in the back of the defendant's store. Now, the defense is right that there wasn't a working light that Chimes could have used at the time. Later, Chimes did implement a light. We won't be using that to show that they should have implemented the light then, but rather feasibility, that they had the ability to do that at the time that Mr. Gilmore was hurt. Additionally, Your Honor, we believe that the defense today is pursuing an affirmative defense, claiming that some other party was responsible for the back dock. The fact that Chimes actually had the power to put that light in goes directly to rebut their affirmative defense. Again, this isn't violative of Rule 407, but goes to feasibility and control.
And are these going in controversy today? Are they saying that they weren't in control?
Yes, Your Honor, that's right. We asked defense counsel to stipulate to that. They declined.
Okay. Since these are going to be in controversy today, I'm going to go ahead and deny that motion.
Yes, Your Honor. With that, the defense is ready to proceed to opening statements.
The plaintiff as well, Your Honor. May I proceed?
You may.
May it please the court. The defendant made dangerous demands. Members of the jury, what if I told you that to walk up a set of stairs with a sharp drop-off at night, outside, in the wind, in the dark, without a light and without anything to hold on to? You probably wouldn't do it. You'd probably tell me that sounds like a bad idea, that sounds pretty dangerous. What if I was your boss? What if I told you that you had to? Today, you're going to meet Jordan Gilmore. You'll hear that that is exactly what happened to him. He's here today because of the dangerous demands that his employer, the Chimes department store, made of him. See, this story starts all the way back in 2005, when Chimes department store rented a new building right here in Waco. That building has a back dock that looks something like this. But that's not what it looked like when they moved in. Today, you're going to learn that there used to be guardrails on that staircase. But when the defendant moved in, they demanded that their landlord tear them off. Members of the jury, that's not just a dangerous demand. You're going to hear that that's against the law. Just a few years later, Jordan Gilmore started working as a cashier at that store. And while he was working at that job, he fell off those dangerous stairs the defendant maintained. Members of the jury, I want to introduce you to him. Mr. Gilmore, could you turn on your camera for a moment? This is Jordan Gilmore. He was a good employee to Chimes department store. He showed up on time. He worked hard. And for over a decade, he did everything his boss told him to do. Thank you, Mr. Gilmore. You can turn that off now. But one of the things his boss demanded of him was that if he wanted to take a break, he had to go down these dangerous stairs to do it. A company policy required it. It doesn't matter if it's dark or if it's windy or late at night, that's where they had to go. And you'll see that when the defendant corporation made those demands of their employees, they knew that it was dangerous. You see, the law requires stairs like these to have a guardrail to keep people from falling off. So on January 23rd, 2019, Mr. Gilmore was out on those stairs for his break. It was dark, it was windy, and he lost balance. He fell. And with nothing at all to stop his fall, nothing to grab onto, he landed hard. He got hurt. He got hurt because of the defendant's dangerous demands. That's why Mr. Gilmore is suing Chime Store for negligence. And as the plaintiff, it's our job to show you that it's more likely than not that the defendant corporation knew that the break area was dangerous, failed to protect its employees from that danger, and that their failure was the direct and proximate cause of the plaintiff's injuries. Today, we'll meet that burden by asking you to focus on 3 key points. First, we'll ask you to focus on what the defendant demanded of their landlord. And next, we'll ask you to focus on what the defendant demanded of their employees. And finally, members of the jury, we'll ask you to take a look at how little they demanded of themselves. Let's walk through each one of those now, starting with the first. What the defendant demanded of their landlord. Because you'll learn that there used to be a guardrail on those stairs. That all along those stairs and all along that landing, there were safety measures in place. But that when the defendant moved into the property, they demanded that the landlord remove it. Now, you might hear them claim today that they did so that they could use those stairs as a loading dock. But we'll show you that they could have done the same thing while keeping employees safe. That brings me to my second point, members of the jury. What the defendant demanded of their employees. Those employees had to use those stairs each and every day. You'll hear from Mr. Gilmore himself. He'll testify that his boss made him use those stairs every time he needed to throw the trash out, every time he needed to take a break. It didn't matter if it was dark, it didn't matter if it was windy or late at night. He'll tell you that his boss knew that this was dangerous, but the defendant never fixed the danger. Which brings me to our third point. Even when the defendant made dangerous demand after dangerous demand of their landlord and employer, they didn't demand anything from themselves. You'll learn that the break area, what's at issue in this case today? Well, the light doesn't work. The employees at Chime Store can't turn on the light. They don't have the ability to. So at night, when it gets dark and hard to see, they can't see anything, members of the jury. You'll hear that the employees complained about how dark it was, complained about how dangerous it was, that the defendant knew removing those guardrails in a dark area with a sudden drop-off could create a safety hazard. But they did it anyway. They didn't demand any diligence from themselves. Members of the jury, at the end of today's trial, I'll speak with you again. I'll remind you of the dangerous demands the defendant made to remove those guardrails, to make their employees use the stairs in the dark, to ignore their employee complaints. after you hear about the defendant's dangerous demands, I'm just going to make one reasonable request. Find the defendant liable. Thank you.
Ms. Holden, you want to go ahead and turn your camera off real quick? Thank you. Go ahead when you're ready.
Your Honor, I just switched my camera and I just wanted to make sure you can still see me and hear me okay.
Yep, everything looks good.
Perfect. May it please the court. 2 moments that made all the difference. One in 2005 and one in 2019. 2 moments that could have prevented this accident from ever happening. 2 moments that the plaintiff really didn't tell you the full story about. So let me do that for you now. Let me spend a couple of minutes with you talking about the actual evidence you'll hear today. Because what will become abundantly clear is that this case isn't about what Chimes demanded. It's about 2 moments that made all the difference. So let's start with that one in 2005. So if you can, take a second and think back. Think all the way back to 16 years ago. Now, that's a really important time for this case because that's when Chimes Department Store, my client, signs a brand new lease to open up a store right here in our town, right down on Bosque Avenue in a shopping center. Now, Reese Geller is the owner of Chimes Department Store. Ms. Geller, could you turn your camera on for a second, please? Now, this is Miss Geller. She has 3 little kids with her husband, Peyton, and they all live here in Waco. Now, to make ends meet, Miss Geller runs her family's business, Chimes. It's just a little store that sells clothes, tools, just about anything you might need. Thanks, Miss Geller. You can turn your camera off again. So in 2005, to be able to open up their family store, Miss Geller's dad has to sign a lease with a corporation called Kermit Realty Group. Now, that corporation, it owns the lot where the shopping center is. You're going to get a chance to see that lease today. It's important because in that lease, there's a map. And that map, it shows you exactly what parts of the lot that the corporation, the landlord, Kermit Realty Group, they held control over. But it also shows you which part of the lot the family's business, Chimes, had control over under their agreement. And you'll see that one of the places the corporation kept control over was the exact spot where 14 years later, the plaintiff, Mr. Gilmore, got hurt. We're going to talk a lot about that exact spot today. And that spot, it's a loading dock in the back of Chimes Department Store. It's where Miss Geller can unload the things that she sells in her store. But you'll learn that when Ms. Geller's dad first opened their family store in 2005, it was the corporation. It was the landlord that kept control of that loading dock. So when Mr. Geller's dad saw that that loading dock had guardrails around it, well, he didn't rip them out himself because he wasn't allowed to. Instead, you'll hear that he told the landlord about it. You'll learn that Ms. Geller's dad sends an email to the landlord of that corporation about that loading dock. And you'll get to hold and see that email later today. And in that email, he asks the landlord, hey, can you remove these rails from the loading dock so that we can use it? And then comes the first moment that made all the difference. All the difference for the plaintiff's accident 14 years later. Because as a response to that email, the landlord says yes, it will remove the guardrails. And that's exactly what that corporation does. It takes responsibility for that spot. It takes control. Members of the jury, you'll see that it was their job because they took control, responsibility for that loading dock. It was the landlord's job to keep that loading dock fixed, to keep it safe, and to keep it secure. Now, that moment when they agreed to taking out that railing, it mattered. But the evidence will show that the landlord, they failed to do its job. And all those years later, when the plaintiff stepped onto that loading dock, it was the landlord's failure that caused the plaintiff to pay the price. So as that concrete crumbled for 14 years, as the landlord failed year after year to take responsibility for what it had to do, Ms. Geller will tell you that she was working hard and kept her business afloat. She was able to hire people to work at her store, including the plaintiff, Mr. Gilmore. And you'll learn that right after the plaintiff started working at Chimes, he started taking breaks out at that loading dock. And the evidence will show that the plaintiff knew the loading dock was dark at night, knew the concrete was crumbling, knew there was a door that sometimes could get in the way of going up and down those steps there. And on the night of the accident, you're going to see that the plaintiff did what he did so often. He went out to the loading dock for a smoke. He walked down those stairs, took his break, and then he tried to come back up. But he then made a choice. And that's that second moment that matters. That second moment that made all the difference. You're going to learn that the plaintiff made a choice to let his friend block his path back inside. You're going to learn that the friend was holding the door open so that it blocked almost the entire step the plaintiff had to use. And the plaintiff chose to take a risk and try to sneak around the edge of it with just inches of that step for him to use. And when he made that choice, in that moment, he fell. When he made that choice in that moment, he got hurt. Ladies and gentlemen, there are two moments that made all the difference. Two moments that caused the plaintiff's injuries. The first was a failure by the landlord. The second was a risk by the plaintiff. And the evidence today, it will be clear. Miss Geller's store, my client's store, Chimes, it can't be responsible for this accident. Because the two moments that made all the difference, they had nothing to do with Chimes. And everything to do with the landlord of the property and the plaintiff himself. Now, at the end of today's trial, I'll get to talk with you one more time. And I'll ask you to find the only verdict that makes sense after you hear all the evidence. A verdict finding Chimes not liable. Thank you.
Plaintiff, you can call your first witness.
Yes, Your Honor, we call Jordan Gilmore. May I inquire, Your Honor?
You may.
Good afternoon, sir. Could you please introduce yourself to the members of the jury?
Yes, my name is Jordan Gilmore.
Mr. Gilmore, why are you here testifying today?
I'm testifying because I got hurt when I was working
Where were you working?
at Chime's department store.
Sir, I want to take a step back and hear a little bit more about you. Where are you calling in from today?
Right now, I'm in Waco, Texas.
Do you live in Waco?
I do.
Do you work in Waco?
I used to, but I'm currently unemployed
Where did you work?
at Chime's.
So let's talk then about Chimes. What sort of store is it?
So Chime's, they sell a little bit of everything. It's kind of like a Kohl's or Dillard's, but a little on the lower end, I would say.
What did you do there?
So I was a cashier. I had, I rang up customers and, did other things, whatever the boss needed me to do.
How long did you work as a cashier?
Roughly 10 years.
I want to focus your attention, sir, on January 23rd, 2019. Were you working that day?
I was.
Do you remember what time your shift started?
I started at noon
How long were you scheduled to work that day?
till close around 8 o'clock.
Did you take a break?
Yes, ma'am. I took a break.
About when did you take your break, Mr. Gilmore?
It was roughly 7 o'clock p.m.
And where did you take your break?
Just on the back landing of the store.
Mr. Gilmore, I'm showing you now Exhibit 19, Your Honor. This has been pre-admitted into evidence. What are we looking at, sir?
This is that back landing I was talking about. It's behind the store.
Now, looking at this photo, it's daylight.
Yeah.
When you went out to take your break at 7 p.m., was it this light out?
No, ma'am.
Well, what was it like?
It was pitch black.
Does the building have any lights outside, sir?
There's just one that I know of.
Was the light on that night?
No, ma'am.
Why didn't you turn the light on, sir?
I couldn't.
I don't understand. What do you mean?
Well, so the store doesn't have the switch to control that light. It's in the Tractor Supply store near it.
Mr. Gilmore, do you have a key to that Tractor Supply store to access that light?
No, ma'am, I do not.
Did you ever tell your boss at Chime's department store that you couldn't turn on the light by the stairs?
I did.
Did they fix it?
No.
Did they install another light?
No.
So how well could you see in that break area at nighttime?
Not well.
Mr. Gilmore, is there a guardrail out there at that loading dock?
No, ma'am.
What about on the stairs leading up to the loading dock? Is there a guardrail there?
No, ma'am.
Well, if there's no light, if there's no guardrail, why did you choose to take a break there?
Because that's what the boss told us to do.
What do you mean?
It was a requirement that if you smoke cigarettes on your break, you had to do it out back and not anywhere else.
Mr. Beachy, could we get Exhibit 1 on the screen, please? Sir, do you recognize this?
I do.
What is it?
This is a memorandum that was sent out instructing us to take smoke breaks out back.
Did you receive this memo, sir?
I did.
Is it a fair and accurate copy of the memo that you received?
Yes, ma'am.
Your Honor, we offer Exhibit 1 into evidence.
Any objections?
Without objection, Your Honor.
It's admitted.
Now, Mr. Gilmore, could you read the highlighted section, please?
Yes, ma'am. The owner does not want any employees taking smoke breaks in front of the store. If you're going to smoke, you need to smoke out behind the store where the dumpster is. That is the only place you should take smoke breaks on the premises.
So, sir, I want to break down exactly what happened when you followed your boss's instructions.
Yes, ma'am.
You go out to the break area, it's dark. What do?
I go out and I go down the stairs and I light up my cigarette.
Were you out there alone?
No, I wasn't.
Who were you out there with?
Riley Huntsberger.
After you were out there, after your break was over, sir, did you try to go back inside?
Yes, ma'am.
What route did you take?
Well, I took the steps back up.
Could you tell us what happened, sir, when you were going up those stairs?
Yeah, I was going back up and I lost my footing and I was falling, so I jumped and tried to save myself and I fell and all the weight was on my right leg and I got hurt from it.
Sir, when you lost your balance, when you fell on your right leg, was there anything for you to hold on to on those stairs?
No,
Was there anything preventing you from falling over the edge?
no,
Did you tell your boss what happened to you?
I told the manager, yes.
When you told your manager that you fell off the stairs in the break area, did she say she was surprised?
No,
Did she say this was the first time they thought about this issue?
no.
What did she say?
Said, yeah, we probably should have fixed those stairs a long time ago. She said that she talked to the owners about it, and there's just a lot of other things to fix right now.
Thank you, sir. Your Honor, pass the witness.
Cross?
Yes, Your Honor.
Go ahead.
Good afternoon, Mr. Gilmore.
Good afternoon.
Now, you've worked at Chimes for about 10 years, right?
Yes, ma'am.
And during those 10 years, you became familiar with the company.
Yes, ma'am.
You became familiar with the company's policies,
Yes, ma'am.
with the space you worked in.
Yes, ma'am.
I want to take a moment to talk about that space that you work in. Now, usually you work in the front of the store, right?
Yes, ma'am.
And you work as a cashier.
Typically, yeah.
But sometimes you would have to go to the back of the store, right?
Oh, it was every shift, pretty much.
Right. And in the back of that store, there's an exit.
Yes, ma'am.
And that exit leads you to a loading dock.
Yes, ma'am.
And that loading dock has a flight of stairs.
Well, a couple of steps, I would say. Yeah, stairs.
Okay, so that loading dock has a couple of steps, right?
Yeah,
All right. And those couple of steps, they lead you to a dumpster.
they do.
Now, sometimes you would go out to the back and take the trash out, right?
Yes, ma'am.
But other times you would take smoke breaks back there, right?
Yes, ma'am.
Now, you couldn't smoke inside the store, could you?
No, ma'am.
You couldn't even smoke in front of the store, right?
No, ma'am.
Right. You had to smoke outside the back of the store, correct?
That's accurate.
Now, in fact, you would go out to that loading dock about 20 times every single week you worked there. Isn't that right?
I think that's right. That's what I estimate.
Okay, so I want to talk to you about one of the times you had to go out there, and that was the night of January 23rd, 2019. So
Okay.
on January 23rd, 2019, you went out for a smoke break, correct?
Yes, ma'am.
And you went out around 7 p.m.
Yes, ma'am.
with one of your coworkers.
Yes, Riley.
And when you went with Riley on your break, it was dark out.
Yes.
You knew it was dark out.
Yes.
So to take your break, you knew that you would have to go to the back of the store.
Yes, ma'am, if I was smoking.
Right. So I want to take a moment to talk about the back of that store. Let's look at a picture of it. Your Honor, permission for my co-counsel, Ms. Bayer, to share her screen with what has been admitted as Exhibit 2.
You may.
All right, Ms. Bayer, can you pull that up for us? Thank you so much. Mr. Geller, can you see Exhibit 2?
Yes, ma'am.
So that's a picture of the back of the store, right?
Yes, it is.
And this is where you were when you fell.
Yes.
But when you went outside that night, it was dark.
Yes, it was.
Now, before you went outside that night, you knew there was no railing near the landing.
I did know that, yes.
And you knew that there was no railing near those steps.
Yes.
You knew that you couldn't turn on the light outside.
Yes.
Okay, so let's take another look at another picture of those steps. Ms. Bayer, could you pull up Exhibit 4 for us, please? Now, this is a picture of those same stairs that we just looked at, right?
They are.
It's just from a different angle, correct?
Yes.
And these are those same stairs that you fell on that night, right?
Fell off. Yes.
Now, before you went outside that night, you knew that there was loose concrete on those steps.
Yes, I did.
You knew that there was an exposed pipe on those steps.
I don't know what you're referring to.
Well, let me direct your attention to that little hole over on the side of the stairs. Do you see that over there?
Oh, yes, ma'am, I do.
So you saw that there was that exposed pipe on the steps, right?
I don't recall about that specific day.
Okay, well, knowing that there was that loose, crumbly concrete, you went outside anyway, right?
Right.
You propped open the back door,
I did, yes.
just like we see here.
Yes.
You went down the steps,
Yes.
took your break,
Yes,
and then you started coming back up those steps.
that's correct.
And as if you were coming back up those steps, the door, it was still propped open.
It was held open by my colleague, Riley.
Right, and your colleague Riley, he was holding the door open just like we see it in this photo here.
Yes.
And it was blocking the landing area in the same way we see it blocking the landing area here.
Yes.
So the door, it looks exactly like this when you come up on the steps on January 23rd, 2019, right?
Yes.
And when you reach the landing step, you put your right foot on the landing.
I'm sorry, I don't understand.
So when you reach that final step, you tried to step up with your right foot on that top landing step. Is that right?
I don't recall.
So you don't remember stepping onto the top step on the night of the accident?
I remember doing that, ma'am. I don't remember if it was my left or right foot.
Okay, so we can agree though that you used one of your feet to step onto that top landing, right?
Yes, ma'am.
And I'm gonna mark that top landing with a circle right here. Now, does that accurately reflect where you put your foot that night?
Yes, ma'am.
And that's when your foot slipped.
Yes.
You felt yourself falling.
Yes.
Mr. Gilmore, before you went up those steps, you didn't shine a flashlight so you could see the steps better, did you?
I didn't have one. No, I didn't.
Well, you have a phone with a flashlight, don't you?
But I didn't take it out that day.
Okay, so you didn't think to take it out and bring it with you to the steps that day, did you?
Not that day, no.
You didn't go around to the front of the store to use the front entrance instead of the back.
No, because we're only allowed to smoke in the back.
But you weren't smoking after you finished your break, were you?
No, ma'am, I wasn't.
So nothing was preventing you from walking through those front doors, was it?
Ma'am, are you asking if I walked all the way around the store to go in through the front? I'm not clear on what you're asking, ma'am.
Yes, I'm asking whether or not you went all the way outside to the front of the store and went through in the front entrance. And you didn't, did you?
No, I didn't.
Right. And when you went up those steps, you didn't push the door so that it was up against the wall either.
No, I didn't.
You didn't even ask your friend to move that door for you.
I don't recall.
You don't recall whether you asked your friend that night to move the door?
I don't recall.
Is there something that would refresh your recollection?
Perhaps.
Would looking at your deposition refresh your recollection?
Yes, ma'am.
Your Honor, I am directing the witness to his deposition. Just give me one moment. Do you have your deposition in front of you, Mr. Gilmore?
I can access it if you want to tell me which part to look at.
It would be the part that you talk about the accident. One second, I'm finding it right now.
Yes, ma'am. I'll try to find it too. Oh, I see it. It's on 13.
Now read page 13 silently and let me know once your memory has been refreshed.
Okay. I'm refreshed.
Okay, I'm gonna ask you to put away your deposition, Mr. Gilmore.
Okay.
And I'll ask you one more time. You didn't ask your friend to move that door for you when you went up the steps that night, did you?
No, ma'am, I did not.
Thank you, Mr. Gilmore. Your Honor, I have no further questions at this time.
Redirect, Your Honor.
Go ahead.
Mr. Gilmore, on cross-examination, defense counsel asked you some questions about the outside area from the dock. Do you remember that?
Yes, ma'am.
She asked you about those crumbling stairs. Remember that?
Yes, ma'am.
Did Chimes grocery
Objection,
store?
leading.
Your Honor, I haven't asked a question yet. I was simply laying foundation. Your Honor.
Just overruled, just continue and be careful with your phrasing.
Mr. Gilmore, did Chimes department store ever fix those crumbling stairs?
No, ma'am.
The pipe that counsel showed you on cross-examination, did Chimes department store ever fix that?
No, ma'am. Not to my knowledge.
She asked you about a flashlight, if you brought a flashlight out with you that night. Did Chimes give you a flashlight to see out on your breaks?
No, ma'am.
Did they provide light at all?
No, ma'am.
No further questions, Your Honor.
Are you ready to move on to your next witness?
Yes, Your Honor. We call our expert witness by deposition pursuant to Rule 804. This witness is unavailable, so I'm going to have my second chair, Mr. Beachy, read some portions out for Your Honor. If there are no objections from defense counsel.
No objections, Your Honor.
Go ahead.
A moment of the court's indulgence, Your Honor. Starting at page 2, line 24. I notice that your CV lists you as PE. What's that?
It stands for professional engineer.
Well, what do you have to do to become a professional engineer?
You have to graduate from an accredited engineering program, which I did. Then you have to pass the fundamentals of engineering exam, which I did. Then you work as an engineer for 4 years before you take the professional engineering exam. So I took that as well, and I passed.
What do you do professionally?
I'm the president of Danes Engineering LLC.
What does your company do?
We provide forensic and investigative engineering consulting and litigation support, specializing in industrial, commercial, and construction engineering, operations, safety, patents, and regulations. So basically, we help to investigate engineering issues in these fields throughout the United States, mostly connected to lawsuits like this one.
Turning to page 8, line 16. Okay, what opinions have you come to in this case?
First, the International Building Code and the regulations from the Occupational Safety and Health Administration apply to the stairs and landing in question, and
Objection,
the
Your
facilities in
Honor.
question.
To improper opinion, if I may be heard. Your Honor, this witness's expertise is asked to an engineer, and it is specific to engineering principles. We just heard his CV moments ago. We have heard no testimony that this witness has any sort of specialized knowledge or training on interpreting statutes and regulations or applying those statutes and regulations to certain facts. It would be improper for this witness, a professional engineer, to give an opinion on statutory interpretation and application. If he was simply testifying to the engineering principles, that would be within his expertise. However, for this witness to apply certain facts to the law, as the witness was about to do, they would have needed to study those statutes and studied their application in some fashion, and it would be improper for the jury to hear the witness apply these laws to the facts of this case without that knowledge at this time.
May I respond, Your Honor?
Go ahead.
This is not an improper legal opinion. Mr. Daines just testified that he investigates cases like these as part of his work as an engineer. He's an industrial engineer who does work on cases just like this. He reviews these types of laws and he's allowed to interpret them. Now, Mr. Daines is talking about exactly what's in his expertise, what OSHA says, what's appropriate and what's not appropriate. That's all he's testifying to.
Okay,
If
Go
I
ahead.
may. This witness is specifically going outside of his expertise. He hasn't told us that he has any training, any specific OSHA related training, any training whatsoever looking at these types of statutes. All we know is that he is specialized in engineering, and this goes beyond that scope. And until the witness can lay the foundation that they indeed have received that specialized training, that specialized knowledge, they can't come to an opinion.
Final word, Your Honor. The witness, in fact, just testified to that specialized training. He said that he specializes in industrial, commercial, construction engineering, and he looks at laws just like this to testify in cases just like this. That's appropriate foundation.
Okay, thank you, counsel. I'm going to overrule that objection. For now, you can continue, Ms. Holden.
Yes, Your Honor.
So, sir, let's look at line 16 on page 8 again. What are your opinions that you've come to in this case?
First, the International Building Code and the regulations from the Occupational Safety and Health Administration apply to the stairs and landing in question, and the facilities in question must be in compliance with these codes and regulations.
We'll turn to page 9, line 9. All right, so which portions of the IBC codes and the OSHA regulations did you find important in this case?
First, the General Duty Clause in OSHA regulations, which can be found in 29 USCS Section 654, and the maintenance provision under Section 3401.2 of the IBC.
Why are those significant in this case?
These are general provisions that require an employer and/or the party that is responsible for maintaining a building or structure to keep that building or structure in a safe and well-maintained condition, free from recognized hazards. Here, as you can see from the photographs that I took during my inspection of the stairs, the broken off concrete, the lack of stair railings, the lack of railings on the platform, the door blocking the pathway, and the lack of a light switch to turn on the light above those stairs were all hazards that should have been identified with a simple and effective safety program. But the defendant didn't have such a program and never identified or corrected these hazards.
Turning to page 11, line 24. What's next?
Next, we move to OSHA 1910.23D1 and 1910.24H and IBC 1009.11.
Why are those significant?
All of those provisions require that stairways or flights of stairs must have guardrails or railings on any exposed side. Here, there was no guardrail on these stairs on the exposed side, which is obviously dangerous.
Do you know if there was ever a guardrail on these stairs?
Yes, there was, and it was removed at some point.
How do you know that?
Well, first, you can look at the photographs and see where the guardrail used to be on those stairs. You can see the broken off piping and the concrete. But second, there's a photograph showing a guardrail on those stairs and that landing.
Thank you, Your Honor. We have no further questions to read this deposition. We pass the witness.
Any cross or further portions of this deposition to be read?
Yes, Your Honor. The defense would also like to read a portion of Ms. Staines' testimony onto the record.
Great, go ahead.
Perfect. Picking up on page 9, line 4. Do you know or have any opinion on who was responsible for the maintenance and repair of these steps behind the Chime store?
No, that's not what I was asked to do.
Going to page 10, line 4. Let me ask you this. If Chimes wasn't responsible for maintaining that area where the stairs were located in the back of the store, would the IBC apply to Chimes in regard to that area?
No, it wouldn't. The IBC applies to whoever has the responsibility to maintain that area. But the OSHA regulations apply to employers generally, so it's a bit different.
Staying on the same page, but skipping to line 19. Do the OSHA regulations place any requirements on employees?
Yes, there is a general duty requirement in 29 USCS section 654B, which says that employees also have to comply with the OSHA standards and regulations and basically have to be responsible for their own actions.
Thank you. Your Honor, we have no further portions of this deposition that we would like to read onto the record.
Any redirect?
No, Your Honor. With that, we rest our case in chief. We would ask for a 5-minute recess.
Perfect. We will reconvene 3:58.
Your Honor, prior to recess, would we like to handle any motions now or after?
You know what? Let's go ahead and handle them now.
Yes, Your Honor. At this time, defense moves for a judgment as a matter of law pursuant to Federal Rule of Civil Procedure 50, as even considering all of the evidence in the light most favorable to the plaintiff, they have failed to meet their burden of proof today. The defense would argue that the plaintiff has failed to meet all of their elements, but specifically the first element, that the conditions of the stairs posed an unreasonable risk of harm, and the third element, that Chimes department store failed to exercise ordinary care to protect Jordan Gilmore from that danger. Now, while the plaintiff has attempted to paint the conditions of the loading dock as dangerous today, we've actually heard testimony that there was a light above the loading dock, that there was light coming out from the store, and that there were only a couple of stairs, in the plaintiff's own words, and that the plaintiff had walked down those stairs thousands of times without any trouble prior to this incident. We haven't heard any testimony that the condition of the stairs, even if you accept the plaintiff's version of those stairs, posed an unreasonable risk of harm. We also haven't heard any testimony that Chimes did not act with ordinary care to keep their employees safe. And because we haven't heard any testimony establishing that Chimes violated the standard of care, no reasonable jury could find for the plaintiff at this time.
Response, Your Honor?
Go ahead.
As Your Honor knows, motions like these are viewed in the light most favorable to the non-moving party. Here, that's the plaintiff. And when viewed in the light most favorable to the plaintiff, a reasonable jury could find that the defendant, was negligent. Now, it's clear based on three things. First, the lack of the light outside in the dark. We heard testimony today that the defendant sends people outside to that break area, both to use the dumpster and throw out trash and to take breaks. And now at nighttime, that area is dark, there's no light, and the stairs are crumbling. Certainly, a reasonable jury could find that the defendant was negligent. Additionally, Your Honor, we just heard from an expert witness, Mr. Daines, who testified that the defendant broke international code and broke OSHA code. So certainly both of those elements go to meeting our burden, and a reasonable jury could find for us now.
Any response?
Your Honor, we still stand by our response that even if we accept that version of those stairs, that even if there was some crumbling, even if there was a little bit of the edge, that we saw that the plaintiff told us that he couldn't even notice that there was exposed pipe, it still wasn't unreasonably dangerous. There was no unreasonable risk of harm. And for that reason, they haven't met their element today.
Thank you, counsel. I'm going to go ahead and deny that motion, and we'll see how things play out with your case.
Yes.
And with that, we will be back now right after 4 o'clock, right at 4:02.
Perfect.
Thank you,
Your Honor.
Okay. Looks like we still have everyone. Let's hope we're ready to proceed. Defense counsel, you may call your first witness.
Yes, Your Honor. At this time, the defense calls Miss Reese Geller to the stand. May I proceed, Your Honor?
You may.
Good afternoon.
Hi,
Could you please state your name for the court?
my name is Reese Geller.
What do you do for a living, Miss Geller?
I am the owner of the Chimes department store down here in Waco.
How long have you been with Chimes department store?
I mean, it's been pretty much since I finished college, but it's been a lifetime job.
Well, how long have you been the owner of the store?
Oh, I've been the owner for the past 10 years. And I took that over from my parents.
Has Chimes department store always been here in Waco?
Well, we've always been here in Waco, yes.
Have you ever moved locations with the store?
Yeah, in 2005, we moved over onto Bosque Avenue.
Did you have to sign a lease to move into that building?
Yes, we did. My dad kind of was more involved in that, but I was still there and helped negotiate with him too.
Would you recognize a copy of that lease that you helped negotiate if I showed it to you today?
I would.
Your Honor, permission for my co-counsel to share her screen outside the presence of the jury with what has been pre-marked as Plaintiff's Exhibit 11, or excuse me, Defense Exhibit 11.
Yeah.
Ms. Bayer, could you share your screen with Exhibit 11 for us? All right, Ms. Geller, what are we showing you right now?
So this is the lease I negotiated with my father and my father signed for the Chimes department store.
And is it a fair and accurate copy of that lease?
Yes.
Your Honor, at this time, defense offers Exhibit 11 into evidence.
Any objection?
No, Your Honor, because this is a contract and it has independent legal significance, we have no objection.
It's admitted.
Ms. Geller, or Your Honor, permission to publish Exhibit 11 to the jury at this time?
Yes.
Thank you. So Ms. Geller, I want to talk about Exhibit 11, and I'm going to direct your attention to the first page, section 1.10. Okay. Do you see where it says demised premises?
Yes, I do.
Now, what's your understanding of that term?
Demised premises means the areas that we're leasing, the store itself, and some parking spots out front.
Who's responsible for maintaining the demised premises?
We were.
Well, where in the lease did it say that you were responsible for maintaining the demised premises?
I believe it was 8.2, section 8.2.
I'm pulling that up for you now.
Yeah.
Can you read the first section of section 8.2 out loud for the members of the jury?
Yeah, tenants shall keep the demised premises in good, clean, and habitable condition, and shall at its sole cost and expense keep the demised premises free of insects, rodents, vermin, and other pests, and make all needed repairs and replacements.
Ms. Geller, was the landlord responsible for any of the maintenance of your property under the lease?
Yes, he was, they were responsible for maintaining just the common areas of that property.
And where does the lease say that?
I believe it's 6.3. Could be wrong. Yes.
We're pulling it up for you right there. Could you tell us what that section says?
Yes, it says landlord shall be responsible for the good and safe operation, management, and maintenance of the common area, and landlord shall operate, manage, and maintain the common area in good, attractive, and safe condition during the lease term.
Did the lease say what areas are included as common areas?
Yes, it was saying parts of the shopping center that were common use for all of the tenants, including like the parking areas, in the streets, in the landscaping, and the loading areas.
What's a loading area?
You know, some of us have seen it, but it's just essentially where the trucks or the vans can pull up and deliver the stuff to the stores. They're in the back of the store, so the customers don't have to see all of the merchandise rolling through the front of the store.
And how could you be sure you knew what area was included in the demised premise under your lease?
Well, we had a map and we just kind of laid it out so we knew exactly what we were leasing and responsible for.
Would you recognize that map if I showed it to you today?
Yes, I would.
Your Honor, permission for my co-counsel to share her screen outside the presence of the jury with what has been pre-marked as Exhibit 12?
Yes.
Ms. Bayer, could you share? Perfect, thank you. Ms. Geller, what are we looking at?
So this is the map that came with our lease. And then that red X is where I marked during my deposition to show where the loading docks were.
And is this a fair and accurate depiction of that map from your lease as you remember it?
Yes.
Your Honor, at this time, defense offers into evidence Exhibit 12.
Any objections?
Without objection, Your Honor.
It's admitted.
Permission to publish Exhibit 12 to the jury, Your Honor?
Yes.
Perfect. Now, Ms. Geller, how did you use this map to determine what areas you were responsible for?
Well, the areas with the crosshatches or the diagonal lines are the areas that we had control over. And so everywhere else was either another tenant or a common area that the landlord, Kermit, had control over.
Could you tell the jury what that red X indicates up at the top of that document?
Yeah, that is where the loading dock was.
Was that loading dock in the demined premise or in a common area?
Well, you can see from the map, it's in a common area.
And how can you see that on that map?
Well, for one, it doesn't have the crosshatches or the lines. It's just kind of blank and, you know, not really indicated otherwise.
I want to shift gears here and talk about the plaintiff in this case. Do you know Jordan Gilmore?
Yes, he was a former employee of ours, and he's also the one that's suing us today.
Were you in court today when Mr. Gilmore testified?
Yes, I was.
Do you know what the back stairs he was referring to during his testimony?
Yes, I do.
Now, which ones are those?
So those were the back stairs that were on the loading dock of our store.
And who was in charge of maintaining the loading dock in the back of your store?
Well, it was, per our lease, it was our landlord, which was Kermit Realty Group.
Well, is there someone at your company who is in charge of inspecting that dock?
No, our company does not inspect the dock because it just wasn't our responsibility. And per our lease, it was our landlord's, and that was what we thought all along.
Well, do your employees use this dock?
Yeah, I mean, we use it for unloading and loading deliveries, to throw trash away, for smoke breaks.
So what, if anything, did you tell your employees about using this dock?
We told them to let us know if there was ever a problem.
Did Mr. Gilmore ever report a problem with the loading dock prior to the fall?
To my knowledge, no. He never told us that there was anything wrong with it.
Did anyone ever report a problem with that loading dock?
Yeah, there was a prior incident where an employee slipped and fell on the steps. And then the manager found that that was a lighting issue.
Well, was there a light on the dock at the time of the incident?
Yes, there was one light.
And who controlled the lighting outside the loading dock?
We didn't have a light switch for the light at the time of the incident, so it was the tenant next to us. But that light itself was in the common area, and that's what Kermit Realty Group controlled.
Did you hear earlier today when Mr. Gilmore testified that he fell trying to walk around the door on the loading dock?
Yes, I did.
Did you hear Mr. Gilmore testify that the door was propped open?
Yes.
Does that door open all the way, Ms. Gilmore? Or excuse me, Ms. Geller?
Yes, it does.
Would you recognize a picture of the back of your store with that door if I showed it to you today?
Yes, I would.
Your Honor, permission to share our screen with what has been previously marked as, or already admitted, Exhibit 6 in evidence.
You may.
Ms. Bayer, could you pop that up for us on your screen? Thank you. Ms. Geller, what does this picture show?
Yeah, so this is the back at the loading dock of my store with the door fully open.
And so is there a railing at this loading dock?
Is there a what? I'm sorry, you broke up.
I'm sorry, is there a railing near this loading dock?
No, there's not.
Well, has there ever been a railing on this dock?
There was, yes, there was.
And why is it not there anymore?
Well, I mean, we used to have one, but then whenever we moved in, we requested with Kermit that the railing be removed.
Well, why did you request that that railing be removed?
Well, it is a loading dock, so the railing kind of made it impossible to load and unload the shipments, and so we had to remove it to use it.
And who did you make that request to?
Kermit Realty Group, which was our landlord.
How did you make that request?
My father sent an email about it.
Your Honor, permission for my co-counsel to share her screen with what has been pre-marked as Exhibit 13 outside the presence of the jury.
Yes.
Ms. Bayer, could you share your screen with Exhibit 13? Thank you. Now, Ms. Geller, what are we looking at?
So this looks like the email from 2005 that my dad sent our landlord requesting the railing to be removed.
And is this a fair and accurate copy of that email?
Yes.
Your Honor, at this time, defense offers into evidence Exhibit 13.
Any objections?
Without objection.
It's admitted.
Ms. Geller, excuse me, Your Honor, before you ask the question, permission to publish this to the jury?
Yeah.
Now, Ms. Geller, why didn't you just remove the railings yourself?
Well, it wasn't, in our demise premises, and so we had to ask our landlord to do it and get their permission.
And when you sent this email, did your landlord, Kermit, tell you that you needed to fix the area on your own?
No, they didn't.
Did they tell you that the loading dock wasn't part of the common area?
No, they didn't.
Did they tell you that the loading dock was in your control?
No, they didn't.
So how did Kermit respond?
They removed the railing.
Thank you, Ms. Bayer. You can stop sharing your screen now. Ms. Geller, you told us that you knew about some problems with that loading dock that your employees used earlier on direct examination. So why didn't you fix those problems yourself?
Well, I mean, it was our landlord's job to make sure that the loading docks were safe, and that because that's what it said in the lease. And I wish that they would have done that, and they didn't.
Thank you, Ms. Geller. Your Honor, pass the witness.
Cross?
Yes, Your Honor. May I inquire?
Go ahead.
Ma'am, I want to start right where you left off. You told us that your landlord, Kermit Realty, that they are responsible for the area behind your store, right?
Yes,
You're claiming today that your business, Chimes Department Store, doesn't actually control that area at all.
yes.
But ma'am, that hasn't always been your testimony, has it?
I mean, I kind of want to see what you're referring to, I guess.
Well, you remember sitting down for a deposition, don't you, ma'am?
I do.
I was there at that deposition.
Yes.
And Miss Piasecki, she was there at that deposition too.
Yes,
I asked you some questions, ma'am, right?
you did.
I asked you some questions about an email from your landlord, right?
You did.
Let's take a look at that email. Mr. Beachy, could you screen share Exhibit 40, please? Do you see that, ma'am?
I do.
Exhibit 40, that's an email from your landlord to you, right?
That's correct.
And in your deposition, ma'am, you say that you agree with every one of the claims made in this email, right?
If that's what I said, then yeah.
I'm asking you, ma'am, if that is what you said. And you told me under oath that you agree with every one of those claims made in Exhibit 40, right?
That's right. So I agree.
Your
So,
Honor,
ma'am,
point of
I
order.
wrote down what you talked.
I asked that counsel state which line in the deposition she's referring to if she's going to impeach the witness.
Your Honor, I'm impeaching the witness on the basis of Exhibit 40. It's on page 13, but the witness already agreed that that's what she said.
Well, just to be clear, Your Honor, the counsel said that she in her deposition said that everything in this email was true. So I'd like to, if I could get a line number of where that says that, just to make sure that that is in fact correct, because we're just looking at an email right now. That's not the deposition.
Of course, Your Honor, it's page 13, lines 9 through 11. But again, the witness already testified that that was her testimony.
Well, it does. I mean, sorry, I didn't know if I could speak up at this point. I really wasn't remembering what you were referring to with my deposition. So,
Your Honor, I'm sorry. There's no question that's pending at the time.
All right, let's move on.
Ma'am, taking a look at this email, that's an email from your landlord, right?
it is.
Your landlord says, right here, you are attempting to blame Kermit Realty Group by claiming that we are the ones that control the area behind your store, right?
That is what it says.
Well, then, ma'am, it says that nothing could be further from the truth. Isn't that right?
Yeah, but then you could look at the lease and say otherwise.
Ma'am, that's not what I asked you. I asked if it says that nothing could be further than the truth. It says that, right?
It does say that, yes.
Ma'am, you agree with that.
With that statement, no.
Ma'am, is it your testimony today that you dispute that statement that's in that report?
I'm saying that it's on Kermit Realty Group, yes.
You remember sitting down for a deposition, ma'am?
I do.
As we just talked about, I was at that deposition.
Yes.
Ms. Piasecki was at that deposition.
Yes.
You would recognize that deposition if I presented it to you in court today?
I would.
Mr. Beachy, could you please screen share the witness's exhibit? This is your deposition, ma'am?
Yes.
You were told to tell the truth in this deposition?
I was.
The whole truth, ma'am?
Yes.
And nothing but the truth, right?
Yes.
So if you could please read silently as I read aloud. Line 9. But do you dispute any of the claims in this email? Answer, no. Did I read that correctly?
Yeah, I mean, part of it, yeah.
So taking a look.
Your Honor, objection. If counsel is going to hand pick certain parts of the deposition to read under the rule of completeness, it's only fair that she read the rest of the answer of the deposition.
Your Honor, may I respond?
Go ahead.
The counsel can certainly redirect her witness about this, but the witness testified that she disagreed with something that was in that statement. In her sworn deposition, she said the opposite. This is a proper impeachment.
Any response?
Your Honor, it was clear that the witness even was trying to explain that that was not everything that was written in the document. And the witness should be allowed to explain the rest of that statement, because if the jury doesn't hear the full statement, it's not a proper impeachment, because counsel is picking whatever she wants and selecting lines, and that's not proper.
I'm going to overrule it for now. When the deposition is in evidence, we've looked at it already. She'll be able to go into that when you redirect her.
Yes, Your Honor.
Statement. Go ahead, Ms. Holden.
So let's look at Exhibit 40. Again, ma'am, you see that right in front of you?
Yes.
A Kermit Realty says we have nothing to do with that area, right?
It does say that, yes.
You don't dispute that, do you?
That the email says that?
No, I'm asking about the claims in that email. You don't dispute any of those claims, right?
I mean, yeah, I do. But, you know,
Ma'am, apologies, go ahead.
No, it's fine. I just I do dispute it because they're saying they have nothing to do with the area. Well, we have a lease with them. They obviously have something to do with the area. So that in itself, I mean, but yeah, I guess I do dispute it to answer your question.
So I want to be clear about your testimony in court today. You're saying that you dispute claims in this email, right?
Yes.
You know, ma'am, that directly contradicts your prior statement.
I don't believe it does, but okay.
So let's talk then about what you control.
Okay.
Now, your employees use the back stairs all the time, right?
Yes.
In fact, you've never seen anyone else use those back stairs.
That's correct.
You've never even heard of anyone else using those back stairs.
Yes, but I mean, who knows who's using it, honestly.
Ma'am, those back stairs, they go directly to your store.
They're, okay, yes.
Not anyone else's store.
Right.
So your employees, they go there when they bring things into your store, right?
Yes.
Where they go to take out the trash, right?
Yes.
That's where they go to take smoke breaks, right?
That's correct.
You know that Mr. Gilmore was taking a smoke break the night that he was injured, right?
That's what he said, yes.
And that's exactly where he was supposed to be.
Yeah.
Because, ma'am, it's your policy that employees are required to go out the back stairs for breaks. Isn't that right?
Yeah, we don't want our customers walking through a bunch of smoke. So yeah, it is our policy.
Is that a yes, ma'am? All I need is a yes or no for the record.
It's a yes.
So let's talk about what conditions that you were sending them into. Now you know that there's one light by the back stairs.
Is that, you want me to answer? Yes?
That's
Yes.
a question, ma'am. You
Yes,
know that
yes.
there's one light by the back stairs.
Yes.
But that light isn't always on, is it?
No.
And in January of 2019, the only switch to turn on that light wasn't outside near the stairs.
Correct.
It wasn't inside near the doorway.
Sure.
It was in a completely different store.
Yes.
You knew that your employees didn't have access to that light switch.
Yes.
They couldn't turn on that light in the darkness even if they wanted to, right?
Yes.
Ms. Geller, you had the power to do something about that, didn't you?
Well, I mean, if it's in the completely other store and it's the common area, there's limited control for me.
But ma'am, you had the power to install another light switch for that light, right?
I'd have to ask Kermit Realty Group to do anything like that.
Is it your testimony today that you had to ask Kermit Realty to install a light switch?
To do any modifications to the property, yes, because we had to ask about the guardrail.
Ma'am, you installed a light switch in 2020, didn't you?
We did.
You did not ask Kermit Realty when you installed that light switch, did you?
That's correct.
So let's talk about another condition that you sent your employees into. Today, your lawyers have been talking a lot about one moment back in 2005. Well, ma'am, I want to talk to you about something that happened back in 2005 as well. There used to be a guardrail along those stairs, right?
Yes.
That guardrail extended all along those stairs up to the landing dock, right?
That's correct.
But in 2005, you demanded that your landlord remove it.
I didn't demand, I asked.
Ma'am, you never asked them to fix the light that those employees couldn't turn on.
Okay, sure.
Ma'am, you never asked them to fix those stairs that were crumbling, right?
Sure.
Now, you say that people could load things into the store through that back area, right?
That's right, they had to.
It's your testimony that that's the reason why you pulled off that guardrail so people could load things into the store. Did I get that right?
Absolutely.
Mr. Beachy, could we have Exhibit 33, please? Your Honor, this is already in evidence. This is a fair photo of what it looks like when people use your loading dock, right?
Yes.
Mr. Beachy, could you draw a guardrail there near the stairs? Ma'am, you agree that a guardrail near the stairs wouldn't stop those people from using the loading dock, right?
For larger shipments, it would.
For some of those shipments, ma'am, it doesn't stop those people from using the loading dock, right?
Yes, but if we need to have all of the shipments, not some of the shipments.
Ma'am, that door is only so wide, right?
That's right. You can push the door and you can put the larger ones in there. That guardrail, if it was there, would prevent that if it was a large shipment. That right there does not prevent it.
But it would also prevent people from getting hurt, wouldn't it?
In some instances.
So I want to talk now, ma'am, about what you knew and when you knew it. You knew that employees had been injured on that loading dock before, right?
Of that incident, yes.
That incident that you're talking about, that happened in 2010, right?
Yes.
It happened at your store.
It did.
Your Honor, permission to show the witness Exhibit 14.
You may.
Ma'am, you recognize this?
I do.
This is that incident report from that event that happened at your store in 2010?
Yes.
Your Honor, we offer Exhibit 14 into evidence.
Any objections?
Yes, Your Honor, this document hasn't been properly authenticated. We don't know whether or not it's been changed or altered in any way. So until that foundation is laid, it can't come in.
May I respond?
Respond.
Your Honor, the witness testified that this was the document that she saw in 2010. It is the same document. She hasn't testified to anything else.
I'm going to sustain the objection until the proper foundation is laid.
Of course, Your Honor. Ma'am, you recognize this document, don't you?
I do, yeah.
That's a document that your company made, right?
Yes.
It's a fair and accurate copy of that recorded statement, isn't it?
Yes.
Ma'am, it hasn't been changed or altered in any way since the last time you saw it.
From what I'm seeing, no. No.
We offer Exhibit 14.
Any response?
Without objection, Your Honor.
It's admitted.
So, ma'am, you knew back in 2010 that other employees had been injured on your loading dock.
Yes, of this incident, yeah.
The person was injured on the same staircase that we're talking about today.
If I'm remembering correctly, yes. Yes.
Now, that person, well, she told you that there was no light, right?
She told April, yeah.
And then you received this document, didn't you?
I'm sure I did, yes.
She said it was dark outside when I opened the door and the light wasn't on.
That's what it says.
Ma'am, she told you that there was nothing for me to grab onto, so I couldn't stop my fall.
Yes, that's what it says.
Ma'am, you received this document more than 10 years ago.
That is correct.
And 10 years later, in your business on the back stairs, there still is nothing to grab onto.
That's correct.
Thank you, Your Honor. Pass the witness.
Redirect?
Yes, Your Honor.
Go ahead.
Ms. Geller, opposing counsel asked you on direct examination about an email that you received from your landlord. No.
Yes, yes.
Did your landlord have nothing to do with that loading dock, in your opinion?
No, that they did not have nothing to do with that loading dock.
What was your understanding of the landlord's relationship to the loading dock?
Well, like I said, per our lease agreement, they had control over that. Anytime we wanted to make changes, such as the guardrail, we had to ask them. And, you know, with the incident report going back to that, I mean, they even mentioned safety in our lease. So that they're involved, not having nothing to do with it.
Thank you, Ms. Geller. Your Honor, I have no further questions at this time.
Defense, call your next witness.
Your Honor, at this time, we have no more witnesses and we close our case in chief. We rest.
Is counsel ready for closing, or should we take another brief recess?
A 5-minute recess would be great for us, Your Honor.
Okay, we will reconvene right after 4:40.
Your Honor, prior to recess, defense does re-raise its motion for Jamal. Would you like to hear argument?
No, that's okay. I'm going to deny it at this time and we'll hear closing arguments.
Yes, Your Honor.
Thank you. Okay, before we proceed with closing, I figured I would give you both a time check. I don't think we're in danger of going over, but might as well. Plaintiff, you have 19 minutes and 52 seconds left. And defense, you have 21 minutes flat left. And Ms. Holden, you can go ahead whenever you are ready.
Yes, Your Honor. The defendant made dangerous demands, and it started right away. Just a few weeks after the defendant moved into the building. That's when they demanded that the only guardrail on the back stairs be removed. They demanded that even though they knew those steps weren't well lit, demanded it even though they knew their employees would sometimes be out there in the dark, demanded it even though they knew that someone could get hurt without it. We can be certain they knew all of that, members of the jury, because of this. It's Exhibit 14. You'll be able to take it back with you in deliberations. This is an injury report from years before Mr. Gilmore was injured. An injury report notifying the defendant corporation of just how dangerous those back stairs were. You'll see what the defendant was told. It was dark outside, and when I opened the door and the light wasn't on, there's nothing for me to grab onto, so I couldn't stop my fall. So years later, a decade later, when Mr. Gilmore went out on those same steps, in those same dark January conditions, you can be certain that the defendant knew just how dangerous their demands had been. But it didn't stop there. What you saw today is that even after the defendant demanded that the guardrail be removed, that the stairs be more dangerous, even after all of that, they demanded that their employees use them. Told employees they didn't have a choice when they took a break. Those stairs were the only place they were allowed to do it. And when Mr. Gilmore did just that, when he followed the defendant's demands, he got hurt. And that's why he filed this lawsuit. Now, members of the jury, as the plaintiff in today's action, we had the burden of proof. And we don't shy away from that. In fact, we embrace it. We had to show you that it was more likely than not. The defendant knew the break room area was dangerous, failed to protect its employees from that danger, and that failure was the direct and proximate cause of Mr. Gilmore's injuries. So the first question we'll ask: what did the defendant know? And when did they know it? We already told you about that prior incident way back in 2010. And that incident is important, ladies and gentlemen, because it's eerily similar to what happened to Mr. Gilmore. That matters because way back then, they had all of that knowledge. They knew that the light was broken, that you couldn't access it from the department store. They knew that those stairs were crumbling. And they knew that without a guardrail, someone could slip, someone could fall, someone could get hurt. But you learn today, members of the jury, the defendant simply didn't care. They didn't do anything to change it. So what did they come before you and tell you today? What was their response? They tried to shift the blame. They said it's someone else's responsibility to keep our customers safe. It's someone else's responsibility to keep our employees safe. And they said we don't control the area. Members of the jury, in a moment, the judge is going to instruct you on the law. And you'll have the jury instructions back with you in deliberation. The judge is going to instruct you that there are actually two ways to show control. One, that the defense told you about, was contractual control. They showed you that lease today. But the other is actual control. What that means, members of the jury, is that if the defendant didn't have contractual control of that area, but used it all the time, was the only one who used it, and actually controlled that area, you can still find them liable. That's exactly what happened in this case. So how do we know that the defendant and the defendant alone actually controlled that area? Well, let's look at what they did. We know that the defendant sent their employees back to that back area for a couple of reasons. Well, they sent them back there for breaks, but they also sent them back there to that dumpster to throw away trash. And members of the jury, the defense today claims that they had no control of that area, that to make any changes to that area, they had to call their landlord. They couldn't do anything without the landlord's say. But that's simply not true. You remember when the defendant was testifying today. Remember what she told you. Well, at first, she said, we can't make any changes to that back area. That light, there's no way that we could change that without notifying Kermit Realty. We couldn't make that light safe for our employees. We couldn't make sure that our employees could see at night. We couldn't make sure that they didn't fall off those stairs in the darkness. That's what she told you. But remember, on cross-examination, what she was forced to admit. Not only did she have the power in 2019 to put that light up, and not only did she have the power without a Kermit Realty, that's exactly what she did later. Members of the jury, the defendant had control of that area. But even if they didn't, the fact is, the fact that the defendant just can't escape today is that they knew just how dangerous that area was. They knew it was dark. They got in complaints about that all the time. You heard that, members of the jury. They knew there wasn't a guardrail because they themselves demanded that it be taken down. And they knew that it was dark. Without a guardrail, those steps would be dangerous. Members of the jury, this is a case about the dangerous choices of this defendant. Because they knew exactly what would happen to Mr. Gilmore that day. It was only a matter of time, members of the jury. When Mr. Gilmore went out to take his break on January 23rd, 2019, he certainly didn't expect to end up broken. He certainly didn't expect to end up hurt. We ask you to find the defendant liable. Thank you.
Can you see and hear me okay, Your Honor?
Yes.
May it please the court? There's a character in this story you didn't hear from today. An important person who had the power to fix the exact problems the plaintiff told you about. A person who actually had control over the spot where Mr. Gilmore hurt his knee. That's the CEO of the landlord corporation, Kermit Realty Corp. The person who actually owns, who actually operates, who actually controls the loading dock that we've heard so much about today. And you didn't hear from them today because the plaintiff wants you to take the easy way out. They want you to take the company that's right in front of you and say that it must be this company's fault. But when you really take a look at it, when you really think about it, when you use your common sense and nothing more, you see that Chimes department store isn't responsible for what happened to the plaintiff. And they aren't responsible because there were two moments in this story that made all the difference. Two moments that had absolutely nothing to do with Chimes department store. Throughout today's trial, the plaintiff has told you time and time again that Chimes department store was negligent in the way they maintained the back of their store. That it was Chimes' fault the plaintiff got hurt. But they can't just tell you that, members of the jury. They had to prove it to you. They had to prove to you that it was more likely than not that Chimes department store was negligent. But in order to prove that to you, members of the jury, they had to prove that it was Chimes' responsibility to maintain the back of that store in the first place. And members of the jury, they didn't meet their burden today. They did not prove that to you. They didn't prove that to you because we heard about those two moments, two parties that made all the difference. We heard that it was the landlord, not Chimes, who was in charge of maintaining that loading dock. And we heard that when the plaintiff failed to open the door before stepping onto that dock, he caused that fall. Now, here in Texas, if other people are responsible, you, as the jury, are allowed to find that someone other than the defendant is responsible. And if it's someone or something else that caused Mr. Gilmore's injuries, then Chimes isn't liable. Now, that's exactly what happened here. And because we're asking you to find that it was Kermit Realty and the plaintiff who were actually responsible for the fall, we had a burden too. We had to prove to you by a preponderance of the evidence, meaning that it's more likely than not that what happened here today was the fault of the landlord and the plaintiff himself. And we've met our burden today. We've proved to you that it was the landlord who had control of that loading dock, who failed to adequately warn the plaintiff and make the dock reasonably safe. We've proved to you that the plaintiff took an unreasonable risk by trying to sneak around the edge of a step when the door was simply blocking his path. And it was those two things that caused this horrible incident to happen. But the Chimes department store, they're not responsible. That's why when you go back to deliberate in just a few minutes, there are two moments you need to keep in mind. One in 2005 and one in 2019. Those 2 moments that made all the difference. Those 2 moments that could have prevented this accident from ever happening. So let's go back to that moment in 2005. Back to 16 years ago when you heard from Ms. Geller that Chimes Department Store signed a lease. Now, you're going to get a chance to look at this lease when you go back to deliberate, but before you do that, I want to take a look at it together right now. So the lease that we were talking about during trial today, that's marked as Exhibit 11. And when you see this lease, you're going to learn that there were 2 types of areas that the landlord company and Chimes had control over. There were common areas, and there were also demised premises. Now, that was a little complicated to understand, even for me. So I liked to look at this map that Miss Geller, she showed us on direct examination, Exhibit 13. Ms. Fair, can we show Exhibit 13 for the jury? Thank you. So Exhibit 13 shows exactly who had control over what area of the building. Now, when I say control, all that means is I'm talking about who's responsible for maintaining the area of the property, making sure it's up to code, making sure it's safe, making sure it abides by whatever terms that were outlined in that initial lease agreement. And if you look real close, you can see that there are these cross-hatched areas on this lease, areas that are crossed out. Now, Ms. Geller, she told you that those were the areas that she was responsible for, that Chimes was responsible for during their lease. Now, the other areas, the blank ones, that was the landlord's responsibility. Those areas were supposed to be controlled by them because some of them were common areas. And one of those common areas was that area marked with an X right there. And you see that red X, and that means that's exactly the spot that today everyone keeps talking about, the loading dock. But under that red X, you can see that there is no crosshatch. There are no markings whatsoever, meaning that on this map, Kermit, the landlord, they knew that they were taking responsibility of this area. And in that lease, it was specifically written, members of the jury, in section 6.1, that they were responsible for the loading docks. And what did Ms. Geller tell you this was? A loading dock. It was written into the contract, members of the jury, and the landlords, they never disputed this. Now, you saw Exhibit 13, which was the email Chimes sent to the landlord asking them to remove those railings. And what did they do when they got this email? Members of the jury, they took control. They ripped out those railings, and members of the jury, their actions, they speak just as loud as the words written in that contract. They did that because they had control of that space. They agreed to keep it safe. So when that concrete crumbled, it was the landlord who left that dock with that exposed pipe we see here. It was the landlord who did nothing to make sure it was a safe area that was usable by its tenants. Even though it was a part of their lease from the very beginning, from 2005. Now, the plaintiff tried to tell you that even though the lease is clear, it was the landlord's responsibility, Chimes should still be held responsible for using something they called actual control over the area. And you saw those words written in those jury instructions that you're going to see when you go off to deliberate. So they tried to tell you basically that when Chimes was asking their employees to smoke in the back of the building instead of the front, to have their employees take out the trash, they were exercising control over the loading dock in a way that under the law It makes them responsible for maintaining it. But members of the jury, when you go back to the jury room to deliberate, you get to take your most powerful tool with you, your common sense. So I want you to use your common sense and think about that argument. Think about a person renting an apartment. Do they exercise control over the commonly shared trash chute? When they walk through the hallway on the way to the front door, does it make them responsible for any accidents that might happen in the hallway if someone were to break their leg? No. Chimes department store had no control over that loading dock. And we've proven to you that it was Kermit Realty who had that control, who had that responsibility to take care of that loading dock, and they failed to do it. So let's talk about that second moment. That moment that the plaintiff made the choice that led to his fall. January 23rd, 2019. We've heard a lot about that day today. We heard that the plaintiff was climbing up the stairs, hand on the wall, and as he reaches the top, he meets an obstacle. His coworker is standing with the door open, making sure there are only inches of space from the edge of the dock to the door. There's only inches of space for the plaintiff to walk through. And instead of doing what a reasonable person would have done, instead of opening the door all the way or asking his coworker to make some room, the plaintiff decides to chance it. He takes fate into his own hands and tries to squeeze through an opening that he would never make. Now, despite what the plaintiff has tried to tell you, we didn't hear today that the plaintiff had no choice but to step around the door. The truth is, we heard the opposite. We heard the opposite from the plaintiff on cross-examination. He told you how many options were available to him. He could have asked his friend to move. He could have lit a flashlight to illuminate the steps. He could have opened the door. He could have used the front entrance. It's not a problem that the plaintiff tried to take those steps back to work that day. Members of the jury, it's just how he went about it that matters. A reasonable person would have simply moved that door out of the way or made another choice. It wouldn't have been hard to do, but the plaintiff didn't do that. And because the plaintiff did not do that, because he took a risk he did not have to, he is responsible for his own actions. Now, the plaintiff's lawyer, she's going to get up here one more time. She has one more chance to talk to you today. And when she gets up here, listen closely to see if she tells you why Chimes should be the party held responsible for those 2 moments they had no control over. Now, if she tells you why Chimes should be responsible for an area that the landlord, the owner of the shopping center, had control over, and when she guarantees that they have showed you enough evidence to meet their burden today, remember, it's not up to them to decide if the evidence is enough. Members of the jury, it's up to you. Find Chimes department store not liable. Thank you for your time.
Rebuttal, Your Honor.
You may.
Ms. Piasecki has been telling you over and over again that there are 2 moments that could have prevented all of this. But members of the jury, I count 5. First, in 2005, when the defendant removed that railing, when they demanded that that railing be removed. I want to be clear about what the defendant is arguing to you with a straight face today. Ms. Piasecki, in her closing argument, she told you that when the landlord removed the guardrails, that was dangerous. But remember who demanded that they do that. It wasn't the landlord who chose to do that on their own. It wasn't the landlord who chose to make sure that happened. It was the defendant. Members of the jury, it was the defendant that demanded those guardrails be gone. They're saying today that it was dangerous to remove those railings. No, it was dangerous to demand it in the first place. Number 2, 2010, you heard today that someone got hurt. You heard that the defendant had knowledge, they were on notice, that someone would get hurt in exactly the same way that Mr. Gilmore got hurt today. There was no light, no guardrail. Those stairs were crumbling and someone fell and got hurt. 2015, the defendant, not the landlord, told people that they had to go outside on those crumbling stairs. They had to go outside in the dark. They had to go outside for their breaks. 2019, Mr. Gilmore gets hurt just like they knew he would. And we know that there was another moment that the defendant, not the landlord, fixed that problem. That light that they claimed only Kermit Realty could fix, that light that they claimed they had no control over, you heard today they did have control over. You heard today that problem, they fixed it themselves. They didn't need the landlord. They didn't need a third party. They didn't need anyone. They fixed that problem themselves. Members of the jury, there are a lot of moments that Mr. Gilmore wishes that he could get back. He wishes that he never walked down those stairs. Wishes he never walked into that store that day. But ladies and gentlemen, in this moment right here, you can make sure that the defendant, that she pays. Find the defendant liable.
Did y'all get your ballots submitted? We'll give comments in a few moments. I still have mine right here. I'm waiting for them to come pick it up, but when they come and grab mine and give us the all clear, we'll give our feedback. Okay, we are good to go. First of all, good job. That was really nice. Especially it's late, long day. I will go ahead and let our scoring judges give their feedback first, and then I'll give any comments as necessary after that. Whoever wants to start, just go ahead.
Tim, do you want to go first? I went first last round we were together.
Yeah, it's your choice. I thought you let us off well, but if you want me to go first, I'm ready. So.
Sure.
All right. So thanks for letting me do this. I'm Timothy Goins. I'm a Lieutenant Colonel JAG in the United States Air Force. I'm also a professor at the United States Air Force Academy. I did mock trial in law school. I also coach it here at the Air Force Academy, and I've judged it a number of times. So kudos. I think you probably hear that a lot. Good job. I thought it was a solid round. You both did really well. I'll limit my feedback to 2 observations, somewhat for you both. The first one is this one was sort of more targeted towards Ms. and I'm going to mess up your name. Is it Pisecki? Is that how you say it? Okay. I don't know.
Okay. Yep.
I was close enough. Okay. So yeah, during your cross-examination, right, you started to do this refresh the recollection bit. I know that's sort of, I think that's becoming somewhat of a more of a trend in mock trial. I don't know why, just impeach them. And so you kind of went through this laborious, well, what would help you refresh your recollection when it's an opposite witness, right? When it's for the opposing side, just go straight into the impeachment. I thought it sort of fell flat. And I think the reason you did that route, I'm not positive, but I think the reason you did that route was because you were trying to end on that note and you kind of wanted this like punctuation point. I actually thought it would have been better if you would have just impeached the heck out of them and then just sat down. And so to that end, when you do the impeachment, make sure you got the page and line ready, dead on. And so that sort of kind of ended the cross with a bit of a whimper. So work on that. And then for Ms. Holden, Same kind of concept. I think your impeachment, you did exceptionally right up until that, it's sort of a crux question, right? The confrontation, you were right there. And it was just sort of a very odd, right? It was an odd confrontation because you're sort of like, well, I've got the email, but then I've got this question and the statement of deposition. How do I confront? And I think you took a route, and it was a challenging one. I would have probably gone the opposite way. I would have probably thrown up. I would have probably talked maybe a little bit about the document and then thrown up the deposition. But the truth is, hindsight's 2020. Yours could have worked out. But anyway, you did great on the credit. You did great on the other stuff, right? And so I thought that was great. That said, so do the impeachment. And the second comment is, I felt like maybe it's just because it's longer in the day. So pardon me if, I've done 2 of these and, it's getting a little late. I felt like it started to get a little drawn out in some of the crosses. I felt like the crosses were a little long for me. I like crosses to be really tight and punctuated with points, like 3-4 points. And if you can't do that in a matter of 10-15 minutes, less than 10 minutes, I would say, I feel like it just gets really long in the tooth, and I think you lose people. And so in any event, so I would maybe, if I were you guys, maybe go through and try to really refine what points do you care about, and really hit those as opposed to kind of hitting everything. But anyway, that was it. Other than that, I thought it was great.
Do you want to go, Stephen, or I can go?
Go ahead, I'll go last.
Okay. Hi, guys. My name is Megan Servage. I am a lawyer in Dallas. I went to Baylor. I graduated a couple years ago, so I'm still a pretty baby lawyer. I work at a boutique business litigation firm in Dallas, and I've tried a couple cases. And I did mock trial at Baylor too. I can't remember if I said that. Y'all were both really great round, both super conversational, which is hard, especially as a female, and especially as a female via Zoom. I feel like I get, constant critique. I'm like conversational, and you both pulled that off. So that was really well. That was really good to see. Just a couple, I guess, critiques, comments on Ms. Holden. I think you did an awesome job, and some of your, I think you missed some objections. There was some testimony on direct, a lot about what Kermit was saying and all these people were saying. And I thought, maybe throw a hearsay objection in there just to sort of throw her off her game. And maybe your camera placement. Is your camera above your head? Because sometimes I think if I'm looking up at a camera, it kind of looks on the camera as if you're maybe like rolling your eyes or maybe you're not looking. So maybe just sort of workshop that, because I couldn't really tell in some parts where your eyes were looking. And when I'm on my laptop now, but when I am in my office and doing Zoom hearings, I always feel like I look like I'm not paying attention to the judge because my camera is sort of up and my eyes are off. So it's really hard with Zoom to look and engage your audience, but just, keep that in mind. What you look like, it's different than, because just the way the Zoom is. And I'm sure you were not rolling your eyes. So, and Ms. Pieski, sorry if I mispronounced that. I think I'll go off with what Tim was saying, that impeachment sort of went wrong for you there. Always have the page in line. It's harder in mock trial, but in practice, I never have a question on cross that I don't have a page in line written under the question, like in my outline, just in case if they answer incorrectly or not what you're expecting, you can immediately go there. Even if it's an exhibit here, with those emails, just have the exhibit listed. I think there was some, can you find it? I can't see it kind of thing. That was sort of unclean. And then one comment about your opening, I was kind of getting confused with calling the landlord a corporation and a landlord. In the beginning, right off the bat, I was like, wait, is there another person? Should I be, is there a corporation, a landlord, and this plaintiff? So maybe just sort of concise, call them one thing so no one is wondering if the corporation is the landlord. Are they different? Is there someone else at play here? But both did an awesome job.
All right. Great job to you both. Congratulations for being invited to this tournament. You're both excellent advocates. My name is Stephen Lopez. I'm a plaintiff's attorney in San Antonio, competed a lot, coached, and have been a judge for many, many tournaments. You both did really excellent. You should be proud of this round. Again, I won't beat a dead horse. That's why when you go last, all the good comments are gone, right? So yeah, I had the same impeachment comment for the defense. You know, it's a choice. Sometimes you take the risk, and sometimes it falls flat, right? So you know, I admire your willingness to take the risk. I think it fell a little bit flat. Overall, you know, I said this in the last round. In my opinion, I think the defense is the harder side of this case so far from what I've seen, just because the control issue is a little tough, and it's not sexy to talk about either. So I'd like, you know, if in the future, as you move into the next rounds, if you can try to find some humanization of Chimes, right, of the mom and pop store, try to bring that out a little more, to try to get a human element in there as well. In this round, I don't know if she's on here, but I'm assuming she's a Baylor Law student. I didn't think your witness was very likable in that role. So I don't know. Hopefully you get like a more likable witness if you're trying to play up the mom and pop angle on the defense side. But great job. Miss Holden, excellent job. I thought you were really great. I'm going to just give you two tiny little technical critiques that you can correct quickly, and it'll serve you in the next round. One of your questions on direct, you were asking your own witness. You said, he said, there's no light out there. He said something like that. And you responded with like, what do you mean? I don't know what you mean. What do you mean there's no light? You said, I don't know what you mean. I mean, that's not believable, right? That's your client. That shows that you're a mock trial student acting. You know, you can ask in a way, you can ask, what do you mean? But I don't know what you mean. Feigning some surprise is it's ridiculous in the real world, and especially ridiculous in a mock trial context. So, you know, you can ask that question, you know, what do you mean? But not phrase it that way, like you're shocked at the answer, because we all know you're not. It breaks the fourth wall a little bit. And then it's kind of the same critique for you, Ms. Holden, in an objection, right? You didn't have an objection because you knew a hearsay exception applied. So you didn't object, but you threw it in there for the judge anyway. And you said, well, because this is a contract and has independent legal significance, you know, like, okay, mock trial student, like, we get it. You understand the exception. Just say no objection, Your Honor, and sit down, right? I think especially in this jurisdiction where we like to keep it super simple, it'll serve you better just to pass it and keep going. But excellent job. And you're both going to do very well. Good job.
Thank you.
I won't add much. I don't want to keep you, especially since you guys are, Ms. Holden, you guys are about to get kicked out of your school in just a moment. A lot of the same comments I had, especially that I thought I had a nice little laugh on the inside when she offered that up. I was like, okay, not going to fight that one. You guys are both great, very easy to listen to, great tone, great pace, very good control over your emotions. Obviously, even like he said, when you're kind of crossing a difficult witness, you kept it all very even and didn't get too combative with her. But at the same time, sometimes when you have a witness like that, they kind of are setting them up to look bad. And you just need to kind of let them, you know, do that themselves. If you argue a little too much with someone like that, it kind of loses it. I think people will understand when you get a witness who really starts to argue with you, and it kind of speaks for itself sometimes. I agree too. The defense case is a little harder. The control thing is not, it's a hard argument. I mean, they use that loading dock at their leisure every single day. It's not like they have to ask permission to use it. So it's kind of hard to argue against that actual control. But I liked that you still kind of emphasize that he made these choices that put himself at risk. And I like that you brought in the whole, like, there's a picture and the door is completely open. He could have done that easily. That was something that they didn't see in the first round that I thought was, that's very obvious that he could have done that. Sorry, yeah, you can go ahead.
I'm so sorry, everyone. They're telling us we have to leave the law school by 6:30. So thank you
You're
all
totally
so
fine.
much. Great round. Thank you.
One burning question I had, if I can just ask you really quickly. So she made the point that this light was added, the subsequent remedial measure was added, and they didn't ask permission. Was it just a matter of adding a light switch on the inside that already connected to the light that was outside?
That's what I'm assuming. It's not like 100% clear. It's like the wall, I'm assuming, also has an access where they could have installed the light, which is why we wanted to keep it out because, you know.
Yeah, just kind of a thought too, because she argued really hard at the end that you guys didn't ask. That clearly kind of flies in the face of the whole control thing. But if it's a matter of just adding something internally, the defendant had control over the inside of the building. They could have done that without asking permission and not running afoul of the terms of the lease agreement. If that gets brought up in the future, I think that's kind of a reasonable inference based on these facts, even if it doesn't explicitly say that. I don't know, just a thought, something, because she really hammered that at the end, and I was like, well, that's not necessarily, I don't know if that's supported by the facts. So I was just kind of wondering that. But other than that, like I said, good job. Good luck in future rounds and everything. And thank you to our scoring judges. We appreciate it.
Thank you so much, everyone.
Good job.
You have a good night. All right, bye, everyone.